Subcommittee at any time. We welcome everyone to this morning's hearing on facial recognition technology, examining its use by law enforcement. Before we begin, I would like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also ask all members to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. As I said, good morning and welcome to a very important hearing, one that I hope will generate not only an understanding, but as I will ask a number of witnesses, legislative fixes that may be relevant and important in this rise of technology, matched against a document that has been a living document for more than a century, obviously centuries, and that is the Constitution of the United States of America. Like many other leaps forward in technology, facial recognition technology offers our society both promise and peril. Proponents extol the potential benefits of modernized policing, greater certainty in law enforcement, safer borders, and ultimately a more efficient criminal justice system. At the same time, facial recognition systems have clear potential for misuse, have been found to be inaccurate at identifying certain groups of people. Moreover, the technology and how it has been used in prosecution raises, as I said earlier, constitutional concerns that call into question the basic tenets of fairness and due process underpinning all criminal prosecutions. The criminal consequences implicated by these darker elements of facial recognition technology warrant closer examination by this body. Congress has found itself at a disadvantage in understanding this powerful tool because the information on how law enforcement agencies have adopted facial recognition technology remains underreported in non-existent. Today, we are beginning facial recognition technology out of the shadows of and into the light. This dialogue must start with the simple question of whether this technology is sufficiently accurate to justify its use by the police, and if the risks of depriving someone of their liberty unjustly are too great. To add untested and unvetted facial recognition technology to our policing would only serve to exacerbate the systemic issues still plaguing our criminal justice system. Worse, large-scale adoption of this technology would inject further inequity into a system at a time when we should be moving to make the criminal justice system more equitable for Americans, as we're working very hard to pass the George Floyd Justice and Policing Act that was passed out of this particular committee some many months ago. There are many unknowns, but we can be certain of one thing. Most, if not all, facial recognition systems are less accurate for people of color and women. For the most part, we can be confident that the darker your skin tone, the higher the error rate. Studies have found error rates in facial recognition software to be up to 34% higher for darker skinned women than lighter skinned men. It is not just sometimes wrong, it can be wrong up to a third of the time. Additionally, a 2019 study by the National Institute of Standards and Technology found empirical evidence that most facial recognition algorithms exhibit demographic differentials that can worsen their accuracy based on a person's age, gender, or race. According to the study, systems varied widely in their accuracy and depending on the algorithm and type of search. America is a multicultural, multi-ethnic nation. This is particularly important as it relates to these findings. Asian and African American people were up to 100 times more likely to be misidentified than white men. Native Americans had the highest false positive rate of all ethnicities. Women were more likely to be falsely identified than men. The elderly and children were more likely to be misidentified than those in other age groups, could play a really strong role in trying to find missing persons, for example, if it was to be used in that. And middle-aged white men generally benefited from the highest accuracy rates. Yet in spite of these flaws, facial recognition technology is being rolled out across the country and has in many instances proven valuable to law enforcement. From the largest federal law enforcement agencies to small local police departments, facial recognition systems are quietly being incorporated into American policing. There lies the complexity, because you have small departments, 18,000 in the United States, that may not have the training and are using these technologies. We have heard the success stories, such as facial recognition technology being used to identify the shooter in the tragic Capitol Gazette massacre and to help identify victims of sex trafficking by matching missing persons photos to online ads. Most recently, we have learned that facial recognition technology has been used to identify several of the insurrectionists who stormed the citadel of American democracy on January 6th. However, while we must applaud the utilization of new technology for the apprehension of domestic terrorists, this must be weighed against the fact that many of the systems, both privately owned or owned by government entities, operate with minimal transparency, limited oversight, and questionable informational security. Let me remind you again, 18,000 different police departments across America of varying sizes, varying training, varying technology capability. And again, it is noted that they are using technology, again, with minimal transparency, limited oversight, and questionable informational security. In some cases, individual employees are testing this private software without the knowledge or approval of their superiors or supervising agencies. Without notice, many communities find facial recognition systems deployed in their neighborhoods. The adoption and use of facial recognition systems must involve community consideration, technological evaluation, and sober legal analysis. As these trends have developed, the federal government has been largely absent. What we do not know towers over what we do, and there needs to change. Seemingly little thought has been put into the widespread adoption of a technology that could materially alter community interactions with law enforcement. This is the issue this committee hopes to correct today and going forward. This hearing is not meant to prejudge facial recognition technology or its value to law enforcement, but rather it is an important first step to proactively engage with this technology and adapt our laws accordingly. As I indicated, it is important that out of this committee hearing, we also work on productive and constructive legislation as needed. I'm looking forward to engaging with the witnesses about the benefits and pitfalls inherent in facial recognition technology and to forging a way forward or towards transparency, equity, and accountability in its use. It is now my pleasure to recognize the ranking member of the committee, subcommittee, the gentleman from Arizona, Mr. Biggs, for his opening statement.
Madam Chair, I thank you for yielding time to me, and I thank you for holding this very important hearing on facial recognition technology and its use by law enforcement. I think there is so much of what you just said that I can associate myself with. There are some things that I think that we can work together on a bipartisan basis, not just you and I, but hopefully all of the members of the United States Congress. Facial recognition technology is a powerful tool when used properly. But when used improperly or relied upon too heavily, it raises some very serious concerns and has some very real-world negative consequences. Today, we'll hear from a witness who was detained after the Detroit Police Department relied on facial recognition technology that pointed the finger wrongly at this man. Facial recognition technology is not perfect, and actually, quite honestly, it's far from it. In order to be reliable, images must be captured in the most favorable conditions with lighting, angle, aging, and other factors, ultimately reducing reliability. Worse yet, facial recognition algorithms perform poorly when tasked with analyzing the faces of women, people of color, elderly, and children. I'm also concerned about the potential First and Fourth Amendment erosions that facial recognition technology can cause. Law enforcement agencies could potentially use the systems for the surveillance of individuals not involved in any suspicious activity whatsoever. Moreover, federal law enforcement agencies, with assistance from their state and local law enforcement partners, have access to images of an overwhelming number of otherwise law-abiding citizens. State motor vehicle agencies possess high-quality photographs of most citizens that are a natural source for facial recognition programs and could easily be combined with public surveillance or other cameras in the construction of a comprehensive system of identification and tracking. Federal law enforcement agencies are also not limited to facial recognition technology systems they control or those controlled by other law enforcement partners at the state and local level. Federal law enforcement can use non-government facial recognition service providers such as Vigilant Solutions or Clearview AI. For example, law enforcement officers with a Clearview AI account can use a computer or smartphone to upload a photo of an unknown individual to Clearview AI's facial recognition system. The system then returns search results that show potential photos of the unknown individual, as well as links to the site where the photos were obtained, such as Facebook or Instagram. The use of facial recognition technology is largely unregulated and raises numerous concerns. The government could use facial recognition technology to monitor or target people exercising their First Amendment rights, including freedom of association. Facial recognition technology also poses significant privacy concerns, and improper use could violate Fourth and First Amendment rights, protecting people from unreasonable searches and seizures and guaranteeing freedom of association. With these constitutional reliability concerns with this technology, the GAO just issued a report indicating that not only have the federal law enforcement agencies not assessed privacy and other risks associated with the use of this technology, some of them don't even know which systems their agents are using. So in sum, I think this is a real opportunity for us to gain some important information and knowledge today. I have enormous concerns that I will summarize here. Technology itself, the technology here is absolutely problematic and inconsistent yet. It's not been perfected. Images of law-abiding people have been acquired. The security of the databases is an issue, as we've seen with recent breaches of databases. Private companies acquiring and scraping information and data and selling it to the feds and other law enforcement. Manipulation and enhancements of photos can take place. It expands the surveillance state that we've been railing against. The GAO report gave some important concerns. And those are just some of my, that's a brief summary of some of these things that I'm concerned with. But I do think it's a place where we can work, Madam Chair, to find common ground. If we're talking about nationalizing police forces, I don't think we'll get there. But if we're talking about finding some kind of meaningful regulation and oversight of the implementation of facial recognition technology, which I think is what the chair is alluding to, then I think we can find a lot of common ground here. With that, Madam Chair, I'd like to submit for the record a letter to the committee dated July 12, 2021 from Matthew Feeney of the Cato Institute.
You want to finish the letter's explanation?
Yes, if I can, please. Also, I wish to submit an article from American Military News from July of 2021 regarding the Capitol Police adoption of Army surveillance gear to monitor Americans and identify threats. I also wish to include several articles about the Alaskan couple that through facial technology that was erroneously used. And that was one would be an AP News article entitled Riots, Technology, Capitol Siege, Government and Politics. Another one from Alaskan News Source and another one from homenews.com, if possible, Madam Chair.
Without objection, so ordered. I thank the ranking member of the subcommittee for his presentation and his opening statement. And I do believe that, as I indicated, that we should be engaged in both oversight and legislative response. And I would like to find common ground with our colleagues, because I think this is very, very important, both in terms for law enforcement and the utilization thereof, but also for the constitutional principles in which we all believe in. It's now my pleasure to recognize the distinguished chairman of the full committee, the gentleman from New York, Chairman Nadler, for his opening statement.
Well, thank you very much. I thank Chairwoman Jackson Lee for convening this hearing on the use of facial recognition by law enforcement. Facial recognition technology is now able to capture images and analyze them in ways that would have been completely impossible only a decade ago. In some cases, the technology enables the real-time surveillance and matching of individuals in a crowd. As facial recognition technology has proliferated in a manner largely unchecked by Congress, we now live in a world where biometric data is collected by private businesses, schools, state and local agencies, and, as is the focus of this hearing, by law enforcement agencies at all levels of government. And there is the tension that we must address. On the one hand, this technology is now a commonplace fixture in our lives. On the other hand, most Americans have little understanding of how the police use facial recognition technologies to conduct surveillance of communities across the country, for better or for worse. Thanks to the work of the Government Accountability Office, we have our first glimpse into federal law enforcement's use of facial recognition technology. In its recent study, GAO found that 20 of the 42 federal law enforcement agencies surveyed use some form of facial recognition technology. But this report, although an important first step, leaves many unanswered questions about how the technology is used, when it is used, and what type of mechanisms are in place to guard against abuse or to protect sensitive data. For example, of the 14 federal agencies that said they used non-federal systems, only one agency could provide the GAO with complete information about what systems their employees were actually using in the field. The picture at the state and local level is even more opaque, but we have received several disturbing reports of the misapplication of facial recognition technology by local police departments. For example, when attempting to match women and people of color. In some cases, facial recognition is deployed without proper consideration of due process rights. One witness here today, Mr. Williams, will testify to the profound impact that a misidentification under these circumstances can have on an individual's life. Simply put, Mr. Williams deserved better from the law enforcement agencies entrusted to use a technology that we all know is less accurate when applied to citizens who look like him. Facial recognition technology can be an important crime-fighting tool, but like all such tools, we need to ensure that the adoption of this new technology does not further erode trust between law enforcement and the communities they serve, and does not compound the unfairness of a criminal justice system that too often disproportionately impacts people of color. Today, the subcommittee begins to ask the critical questions surrounding police use of facial recognition technology. The hearing will not answer every question about the adoption of facial recognition technology by law enforcement, but my hope is that we will take another important step toward balancing the needs of law enforcement agencies, the priority of keeping Americans safe from crime, and the valid concerns about this technology expressed by communities across this country. Our task is not an easy one. We want an America where every individual knows that they and their family are safe from harm, while our fundamental rights are protected. We want an America where law enforcement has the tools it needs to protect and serve, but with clear guidelines and rules that prevent those tools from being abused. Understanding how to make that vision real at a moment when technology keeps changing and evolving will take a tremendous amount of work, but this is worth doing. Again, I thank the chairwoman for calling this hearing. I look forward to hearing from our witnesses, especially Bertram Lee, who once worked for my office way back when. It's good to see you, and I look forward to your testimony. I thank all of the witnesses for taking the time to engage with us on this important topic, and I look forward to their testimony, and I yield back the balance of my time.
I thank the chairman very much for his presentation, important presentation. And now it's my pleasure to recognize the distinguished ranking member of the full committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, thank you, Madam Chair. I look forward to today's hearing on facial recognition technology. I'm hopeful we can approach this issue in a truly bipartisan manner, as has been mentioned by some previous statements. Last Congress, we worked closely with our colleague, the late Chairman Elijah Cummings, on this very issue. While we had many vigorous debates on a variety of issues, facial recognition technology was one issue where we shared common ground. So much so that we held 3 bipartisan hearings in the Oversight Committee on this technology. In those hearings, We learned many important facts about facial recognition technology. There are serious First Amendment and Fourth Amendment concerns about the use of FRT by law enforcement. There are also due process concerns about how law enforcement uses this technology. We learned, for example, that over 20 states, departments of motor vehicles have handed over their driver's license data to the FBI. No American citizen gave their consent to have their data and images turned over to the FBI. No elected official ever voted to allow this to happen. Every American should be troubled by this. I know I am, and I hope my colleagues on this committee are as well. Almost 2 weeks ago, the GAO issued a new report about how federal law enforcement uses FRT. This report makes clear that the federal law enforcement agencies using facial recognition technology haven't even assessed the risk when using this technology. If they haven't even assessed the risk, they certainly aren't taking them into consideration when they're using the technology. GAO surveyed federal law enforcement agencies on their use of facial recognition technology. 14 agencies that reported using the technology to support criminal investigations also reported using systems owned by non-federal entities. Only one agency had awareness of what non-federal systems are used by its employees. In other words, not only are federal law enforcement agencies not assessing the risk of using facial recognition technology, most don't even know which systems their employees are using. I imagine it's difficult for a federal agent to assess the risk of using a system if it doesn't even know which system it is using. I look forward to learning more from GAO on this recent report and our other witnesses on the path forward. With that, Madam Chair, I yield back.
I thank the gentleman for his opening statement. Without objection, all other opening statements of our members will be included in the record. I will now introduce today's witnesses, and let me again thank them for their participation. This is a virtual hearing that is no less crucial and important, and we thank you for participating in that manner of technology. The first witness, Director Greta Goodwin. Greta L. Goodwin is a director in the Homeland Security and Justice team at the U.S. Government Accountability Office, where she leads GAO's work on justice and law enforcement issues. Her portfolio includes federal law enforcement in oversight and training, civil liberties, civil rights, vulnerable populations, the federal prison system, and the federal judiciary. Director Goodwin has a PhD and a master's degree in economics from the University of Nebraska Lincoln and a bachelor's degree in economics from the University of Houston. Glad to see there's a Houston connection and the university that I happen to represent. Welcome. Professor Barry Friedman serves as the faculty director of the Policing Project at New York University School of Law, where he is a Jacob D. Fuchsberg Professor of Law and affiliated Professor of Politics. Professor Friedman has taught, litigated, and written about constitutional law, the federal courts, policing, and criminal procedure for over 30 years, and has produced numerous books and articles appearing in various scholarly journals and popular media outlets. Friedman graduated with honors from the University of Chicago and received his law degree, magna cum laude, from Georgetown University Law Center. Welcome. Robert Williams is a 43-year-old man who lives in Farmington Hills, Michigan, with his wife and 2 young daughters. He works as a logistics planner in the automotive industry. Mr. Williams was wrongfully arrested by the Detroit Police Department in 2020 when facial recognition technology misidentified him. Mr. Williams, we apologize to you and very grateful for the testimony that you'll be presenting here today. Welcome. Bertram Lee Jr. Is a counsel for media and technology at the Leadership Conference on Civil and Human Rights, where he works to advance the interests of marginalized communities in technology and media policy. His portfolio includes broadband access, media diversity, facial recognition, law enforcement surveillance technologies, Section 230 of the Communications Decency Act, algorithmic bias and artificial intelligence. Previously, Mr. Lee worked as policy counsel at Public Knowledge and at the U.S. House Committee for Education and Labor under Chairman Robert C. Scott. He received his JD from Howard University School of Law and his BA from Haverford College. Welcome. Kara Frederick is a research fellow in the Center for Technology Policy at the Heritage Foundation. Her research focuses on big tech and emerging technology policy. Among her prior roles, Ms. Frederick was a fellow at the Center for New American Security served as a senior intelligence analyst for a U.S. Naval Special Warfare Command, and helped create and lead Facebook's global security and counterterrorism analysis program. She received her MA in War Studies from King's College London and her BA in Foreign Affairs and History from the University of Virginia. Welcome. Professor Jennifer Lauren serves as a Wright C. Morrow Professor at the University of Texas School of Law, where she studies and writes about law and institutional design shape the functioning of criminal justice institutional. She also currently serves as reporter to the American Bar Association's Criminal Justice Standards Task Force and is the former chair of the Texas Capital Punishment Assessment Team, organized under the auspices of the American Bar Association. Professor Lauren received her undergraduate degree in politics from Earlham College and her JD from Columbia Law School. Welcome to you from Texas. Brett Tolman is the executive director for Right on Crime. He is the founder of the Tolman Group and previously served as a shareholder at the law firm of Ray Quinney and Nebuca, PC. Previously, Mr. Tolman also served as U.S. Attorney for the District of Utah and was selected by Attorney General Michael McKenzie to serve as a special advisor to the Attorney General on national and international policy issues affecting the United States attorneys and the Department of Justice. Prior to becoming U.S. Attorney, Tolman served as legal counsel to the United States Senate Judiciary Committee. He received his BA and his JD from Brigham Young University. Welcome. Dr. Cedric Alexander is a law enforcement expert with over 40 years of experience in public safety. He has appeared on national media networks to provide comment on police community networks to provide interests in that area and has written numerous editorials and books on the subject. Previously, Dr. Alexander has served as Deputy Commissioner of the New York State Division of Criminal Justice Services, as Chief of Police of DeKalb County, Georgia, and as National President of the National Organization of Black Law Enforcement Executives, a very powerful law enforcement organization. He was also appointed to serve as President Obama's Task Force on 21st Century Policing, received a BA and a master's degree from St. Thomas University in Miami, Florida, and a doctorate from Wright State University. Welcome. Usually I stand when I provide the oath, but we welcome our distinguished witnesses and we thank them for their participation today. And so I'll begin by swearing in our witnesses. If you would please turn on your audio, make sure I can see your face and your raised right hand while I administer the oath. Please unmute and let me see your raised right hand. Do you swear or affirm under penalty of perjury that your testimony you are about to give today to be true and correct to the best of your knowledge, information, and belief, so help you God?
I do.
Yes,
Here at Audible, I do.
I do.
I do.
I do.
Thank you so very much. Let the record show the witnesses have answered in the affirmative. Thank you so very much. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. There is a timer in the Zoom view that should be visible on your screen. Director Goodwin, you may begin. Welcome. You're recognized for 5 minutes.
Thank you. Chairman Nadler, Chair Jackson Lee, Ranking Member Jordan, Ranking Member Biggs, and members of this subcommittee. I'm pleased to be here today to discuss federal law enforcement's use of facial recognition technology. Use of this technology has expanded in recent years, and questions exist regarding the accuracy of the technology, the transparency in its usage, and the protection of privacy and civil liberties when the technology is used. Today, I will discuss 1, the ownership and use of facial recognition technology by federal agencies that employ law enforcement officers. 2, the types of activities these agencies use the technology to support. And 3, the extent that these agencies track employee use of the technology, especially those owned by non-federal entities, as well as the potential privacy and accuracy implications. We surveyed 42 federal agencies that employ law enforcement officers. 20 of them reported that they owned a system with facial recognition technology or used another entity's system. Of these 20 agencies, 3 owned their own system, 12 only used another entity's system, and 5 agencies both owned a system and used another entity's. These agencies noted that some systems can include hundreds of millions or billions of photos. Federal agencies reported using facial recognition technology to support various activities, such as criminal investigations, surveillance, and managing business operations during the COVID-19 pandemic. Of the 20 agencies that owned or used the technology, 14 reported using it to support criminal investigations, including investigations of violent crimes, credit card and identity fraud, and missing persons. Looking more closely at these 14 agencies, some of them told us that they used the technology last summer to support criminal investigations related to civil unrest, riots, or protests following the killing of Mr. George Floyd in May of 2020. In addition, a few of these agencies told us they used the technology on images from the US Capitol attack on January 6th of this year to generate leads for criminal investigations. Of these 14 agencies, we found that 13 did not have complete, up-to-date information on what non-federal systems are being used by their employees. So agencies have not fully assessed the potential risk related to privacy and accuracy of using these systems. To be clear, some agencies knew that employees were using certain systems. For example, agencies may have had formal agreements with states or contracts with private companies. However, many agencies had to poll their employees to answer our questions, and multiple agencies initially told us they didn't use the technology and later changed their answers after talking with employees. What these 13 agencies all have in common is that they don't have a process to track what federal systems employees are using. Although the accuracy of facial recognition technology has increased dramatically in recent years, risks still exist that searches will produce inaccurate results. If a system is not sufficiently accurate, it could unnecessarily identify innocent people as investigative leads. The system could also miss investigative leads that would otherwise have been revealed. Moreover, the technology's high error rates for certain demographic groups could result in adverse consequences for individuals. Accordingly, we recommended that agencies implement a mechanism to track what non-federal systems with facial recognition technology are used by employees to support investigative activities, and assess the risk of using such systems, including privacy and accuracy related risks. Facial recognition technology's capabilities are only going to grow stronger. If law enforcement agencies do not know if or how their employees are using the technology, then they cannot ensure that the appropriate protections are in place. Chairman Nadler, Chair Jackson Lee, Ranking Member Jordan, Ranking Member Biggs, and members of this subcommittee, this concludes my remarks. I'm happy to answer any questions you have.
Thank you for your testimony. I'm now pleased to recognize Professor Barry Friedman for 5 minutes.
Chair Jackson Lee, Chair Nadler, Ranking Members Jordan and Biggs, members of the subcommittee, I want to thank you for giving me the opportunity to testify today. As my introduction indicated, I am the founding director of the Policing Project at New York University School of Law. I wanted to tell you our mission because it relates directly to what you're doing today. We are an organization that partners with all stakeholders. We work in impacted communities impacted by law enforcement. We also work closely with law enforcement agencies with the goal of bringing to policing democratic accountability, transparency, and equity, particularly around issues of race. I want to stress 2 parts of that because I think they relate directly to this hearing. First, the issue of democratic accountability. It's our position, this is one of my key points that I'd like to make today, that these technologies should not be used without proper democratic accountability. Accordingly, I commend the subcommittee for having this hearing to pursue what I think is essential legislation in this area. And second, I want to stress that we do work with all stakeholders across the ideological spectrum, and I was incredibly gratified to listen to all of the members who spoke to the need and the ability to work in a bipartisan way on this issue. I believe that we can, that there are strong, passionate feelings about this technology. It's a very powerful technology, but there is a way forward on the technology, and the question is, how do we get there? So I want to turn to that. The approach that we use at the Policing Project is one of, particularly for emerging technologies around policing, is one of cost-benefit analysis. We look at the benefits of the technology. And as many of you said, there are definitely benefits that can be obtained from this technology. And then we look at the costs. And as many of you have indicated, there are very, very serious costs, very, very serious potential harms. There are racial harms from the disparities. There are privacy harms. There are harms of giving too much power to government, as we can all see by use of this technology by totalitarian governments. There are concerns about the First Amendment. Now, some people look at cost-benefit analysis and they think, okay, well, we weigh the costs, we weigh the benefits, we decide whether to do something or not. But that's exactly the wrong approach. The value of cost-benefit analysis or benefit-cost analysis is that we can find a nuanced way to regulate that can maximize the benefits and minimize or mitigate entirely the harms. And that's what I want to talk about. I've spoken to many, many people over the last months and in fact years about this issue. There are strong views on both sides, including some people who after much reason think that the technology should be banned. But the fact of the matter is that when I'm talking to law enforcement or when I'm talking to civil libertarians or racial justice advocates, whether I'm talking to people in the technology companies themselves, even though they disagree about the use of the technology and about many things, there's a wide swath of agreement about what isn't okay in the use of the technology, about what are shoddy and dangerous practices that should be regulated. And I want to just dive very quickly into some of the nuance of those practices, and you have a longer enumeration in my testimony, and I'm happy to answer any questions. So first, issues of accuracy and bias. We've heard a lot about that. And I think it's time, and I hope that we will all stop saying things like the technology is 87 or 93 or 95% accurate. That doesn't mean anything. We should be talking about false negatives and false positives. That's what matters. But the truth of the matter is we don't know anything about the accuracy of this technology when law enforcement uses it. And that is because law enforcement uses the technology in a way different than it has been tested by NIST. Law enforcement uses different probe images than NIST has tested. Law enforcement uses much larger databases than NIST has tested. As you think about it, the error rates just increase as the databases get larger. And we don't even know if NIST has tested the the algorithms that law enforcement is using. Now, a lot of people say, okay, not to worry, there's a human in the loop. But now I would appeal to your common sense. We don't have enough science, but we have some. Humans in the loop can be a good thing or a bad thing. Humans in the loop would be a good thing if an independent individual who had no idea of what the algorithm had suggested identified the same person. Humans in the loop are problematic if all they're doing is confirming what the algorithm told them. And so again, we need testing and methods of ensuring that if there's a human in the loop, that human is actually working in a way to make sure that we eliminate concerns about accuracy and demographic, particularly racial bias. And finally, I want to urge you to think very seriously about regulating the vendors themselves. That's the touch point. Those are the folks that know how the technology works and what can be done to make it work. They could work on what are acceptable probe photos, what are the right settings to make sure we get accurate results. I have a long list of things the vendors could regulate, but I'm out of time. And so I'm just going to thank you for listening to my testimony and happy to answer questions.
Thank you very much, Professor Friedman. It's now my pleasure to recognize Mr. Robert Williams and welcome Mr. Williams again. I indicated my apologies. We are the presiders over law enforcement in this nation, and certainly we welcome your very important testimony. Thank you.
Thank
You're
you.
recognized for 5 minutes.
Okay. Chair Nadler, Chair Jackson Lee, Ranking Member Jordan, Ranking Member Biggs, members of the subcommittee, thank you for the opportunity to testify today. Not last January, but January 2020, I got a call from my wife and she told me that some detectives called her to tell me to turn myself in. She said they'd be calling me shortly because they didn't have my phone number. They called me. I answered and said, I asked him what was it about. He told me he couldn't tell me. All he knows is that I need to turn myself in. I assumed it was a prank call. I hung up and called my wife and told my wife to disregard, who was irate and thinking that maybe I was trying to hide something from her. So I told her to call our local police department. She did. They said they had no no warrants or anything for my arrest and to disregard the call. So I proceeded to drive home. I went, and when I got home, there was a Detroit police car parked on my street. And when I pulled in the driveway, he pulled in my driveway and blocked me in as if I was gonna make a run for it. He pulled up. He said, "Are you Robert Williams?" I said, "Yes, I am." He said, "You're under arrest." I said, "Whoa, you can't just arrest me for that. What am I under arrest for?" He said, "Don't worry about it," and proceeded to put the handcuffs on me. I told my wife and my kids who were coming out the house at the time, "Don't worry about it. They're making a mistake. I'll be right back." Unfortunately, I wasn't right back. I ended up spending 30 hours in jail. Um, I, well, at the detention center, but while I was in the car, I asked again, "Why am I being arrested?" And they said, "We can't tell you that," but they showed me the warrant that said felony larceny on it, and I didn't steal anything. I'm like, how do we get the warrant? He said that a detective would be in to talk to me. I was in the detention center in an overcrowded cell. The garbage was overflowing. It was a lot of less desirables in there talking about things that they had done and things that they got away with. And I'm just like, why am I here? And nobody ever came to tell me. So the next day when I went to court, I pleaded not guilty. They took a recess, and then some detectives came to ask me some questions. When they came to ask questions, they had me sign a paper saying that I would waive my right to counsel so they could show me what was on the papers. I signed. He showed me a picture. He said, well, first he said, "When's the last time you was at the Shinola store?" I said, "A couple years ago." He said, "So that's not you?" I said, "No, that's not me." He turns over another piece of paper. He says, "So I guess that's not you either." I held that piece of paper up to my face. I said, "I hope you don't think all black people look alike." He turned over another paper and said, "So I guess the computer got it wrong." And I'm like, "I guess so. Am I free to go?" And he was like, I'm sorry for this mishandling, but we're not detectives on your case, so we can't let you go." So they sent me back to my cell. Right. I received a bond. I got out. Um, my wife contacted the ACLU, and we started getting information about the case, and we realized that it was a wrong facial recognition policy, technology used, and I just been fighting for it ever since. I just don't think it's right that my picture was used in some type of lineup, and I've never been in trouble, right? With that being said, I'd just like to say thank you for the opportunity to share my testimony, and I hope that Congress does something about this law. And I'm happy to take any more questions that you might have for me.
Powerful statement, Mr. Williams, and you're tracking what I began with as I opened this hearing, that not only should we engage in oversight, but I do think we should engage in the right kind of fix, and very apologetic to you and your family for having to go through this. Our next witness is Mr. Bertrand Lee Jr. You're recognized for 5 minutes.
Chairwoman Jackson Lee, Chairman Nadler, Ranking Member Jordan, Ranking Member Biggs, and members of the subcommittee, thank you for the opportunity to testify today. And thank you, Chairwoman Jackson Lee and Chairman Nadler, for calling this hearing and shining a light on the serious and undeniable threat that facial recognition technology poses, especially to Black and Brown people and other marginalized communities. We are at a turning point. We must reject policies and practices rooted in discrimination towards marginalized communities and move toward a new paradigm for public safety that respects the humanity, dignity, and human rights of all people. The Leadership Conference has spoken out against law enforcement use of facial recognition since 2016, highlighting the inherent bias of these tools and their disparate impact on marginalized communities that are already over-policed. Last month, the Leadership Conference, along with Upturn and New America's Open Technology Institute released a statement signed by 40 advocacy organizations that outlined 6 of our most pressing civil rights concerns about facial recognition technology, including that its use exacerbates the harms of policing in communities that are already targeted by the police, threatens individual and community privacy by allowing invasive and persistent tracking and targeting, chills First Amendment protected activities, violates due process rights, and otherwise infringes upon procedural justice, often relies on face prints that have been obtained without consent, and lastly, in addition to racial bias with respect to how law enforcement uses facial recognition, the technology itself poses a disproportionate risk of misidentification for Black, Asian, and Indigenous people. The possibility for misidentification and misclassification poses a tremendous threat to the health, safety, and well-being of communities. The reasons for these problems and inherent biases vary. In some cases, the cause of the bias lives within the database that an image is searched against. In others, it is due to the historical bias built into the algorithm itself. The end result, however, is the same. Black people are disproportionately represented in law enforcement facial recognition databases, and inequitable error rates further entrench racial disparities in the criminal legal system. For example, in a comparison of match rates by country of origin, photos of people from East African countries had false positive rates 100 times higher than the baseline rate. Researchers also found that some facial analysis algorithms misclassified Black women nearly 35% of the time, while always getting it right for white men. But even if the accuracy of facial recognition technology was improved, the fundamental issue remains. Facial recognition technology dangerously expands the scope and power of law enforcement. When combined with existing networks of surveillance cameras dotting our urban and suburban landscapes, facial recognition algorithms could enable governments to track the public movements, habits, and associations of all people at all times, merely with the push of a button. According to a report from the Georgetown Center on Privacy and Technology, more than 133 million American adults are included in facial recognition networks across the country, and at least 1 in 4 state or local police departments can run facial recognition searches through their own network or the network of another agency. As facial recognition technology rapidly emerges in everyday police activities, safeguards to ensure this technology is used fairly and responsibly are virtually non-existent. As Congress considers how our nation's systems of policing and punishment disproportionately harm communities of color, it must decelerate law enforcement's ability to wield such powerful technology, particularly when the history and recent abuses provide little reason to think it would be used responsibly. We are safer when our communities are healthy, well-resourced, and thriving. Policies of mass criminalization and over-policing are fueled by white supremacy, not a belief in justice. And tools like facial recognition technology are about social control, not public safety. The Leadership Conference urges members of Congress to act now to protect the public from this technology, specifically by implementing a ban or moratorium on law enforcement use of facial recognition tools. Families and communities will continue to endure unspeakable harm and tragedy on our government's watch as long as we allow these policies to continue. Time is of the essence. The Leadership Conference looks forward to working closely with the subcommittee to address the serious concerns with this technology and work toward a new vision of justice that truly keeps communities safe. Thank you.
Thank you very much for your testimony and as well for that insightful constitutional analysis, which is extremely important. I'd like to recognize Ms. Kara Frederick for 5 minutes.
Chair Nadler, Chair Jackson Lee, Ranking Member Jordan, Ranking Member Biggs, thank you for the opportunity to testify today. In 4 years, a projected 6 billion people will have access to the internet, with 80 billion devices connected to the web. This creates profound digital surveillance opportunities, and facial recognition is a standout capability. Some uses of facial recognition comprise legitimate public safety imperatives, finding the Capitol Gazette shooter, as the chairwoman mentioned, and detecting individuals using fake passports. But the potential for abuse by agents of the state is also high. Risks are manifold, like inaccurate algorithms and data security vulnerabilities. But I want to focus on 3 risks in particular. Number 1, the circumscription of civil liberties and individual privacy. The FBI is leading the way in the use of facial recognition for domestic surveillance. Today, the Bureau has access to over 640 million photos, in some cases through the use of private companies that scrape social media sites unbeknownst to the subjects. Number two, outsourcing that surveillance to unaccountable private companies. Reports that the Biden administration intends to expand the use of private companies unencumbered by constitutional strictures and with a history of reckless privacy practices are troubling. Although government entities like DHS have long used private firms to identify patterns in publicly available information, a renewed push to make use of outside expertise for domestic spying on the heels of the new White House plan to counter domestic extremism portends potential Fourth Amendment concerns. Such impulses to outsource domestic surveillance can lead to more expansive monitoring by law enforcement, which leads to the third risk: the potential integration of facial recognition data with other PII through the expansion of mass surveillance. The technical capabilities are already here. Now, multiple data sources can be aggregated and synchronized to allow governments to look for patterns in citizens' behavior. Faster networks with lower latency provide quick transmission and higher throughput to handle increased data flows. More compute power and options, along with developments in machine learning and analytics that extract value from data, all fit together in mutually reinforcing ways, combining to weave diverse data streams into a grid of total surveillance if desired. This can engender a climate of fear, self-censorship, and the chilling of free speech and the right to peaceably assemble in public places. While authoritarian powers like China are at the bleeding edge of using facial recognition for internal control, the demonstrated inclination by governments to expand these powers in democratic nations renders the slope a slippery one. And we know that once these powers expand, they almost never contract. The trend lines are foreboding. The United States nearly matches China in its surveillance coverage, with 1 camera for every 4.6 people, compared to China's 1 for 4.1 individuals. Municipalities are using COVID as justification for expanded surveillance, as in the case of Petrie Corners, Georgia, which became the first US city to use AI-driven smart cameras to monitor social distancing and the use of masks this year. Combined with near historic low levels of public trust in the government to do what is right, the unfettered deployment of these technologies will continue to strain the health of the body politic without immediate and genuine safeguards. Technology has long outpaced our efforts to govern it. To constrain abuse and bound expansion, Congress should establish a federal data protection framework with appropriate standards and oversight for how US user data is collected, stored, and shared by federal, state, and local entities. The initial focus of the effort should establish clear policies on data retention, categorize biometric surveillance data as sensitive data, limit interoperability and data integration practices to stymie mass surveillance. Congress should ensure that US identity management systems are secure and reliable based on proper standards and measurements and in accordance with NIST guidelines. Programmers should build in data privacy protections in the design phase, testing new methods of encryption or differential privacy, decentralized models of data storage, or federated models of machine learning for these systems. In sum, the debate over public safety and privacy trade-offs in our republic provides an opportunity for us to embed technology with privacy protections from the outset and to shore up a system of checks and balances to redress privacy infringements that do occur. But we are balanced on a razor's edge. How we decide to use and safeguard these technologies today either draws us closer to the free and open republic we should be, or closer to the authoritarian states whose surveillance practices we profess to abhor. I look forward to taking your questions.
Thank you very much for your testimony. We're now able to recognize Professor Lauren for 5 minutes.
Chair Jackson-Lee, Chair Nadler, Ranking Member Biggs, Ranking Member Jordan, and members of the subcommittee, thank you very much for the opportunity to address the subcommittee on the topic of facial recognition technology. I will speak to a small but important sliver of this vast and complex topic that intersects with my own research and teaching on forensic science and criminal investigation and adjudication. The 3 bottom line points I want to leave you with are these. First, although facial recognition technology matches have not been held to be admissible in evidence in criminal cases, law enforcement use of facial recognition to identify suspects does form the basis for arrests, criminal convictions, and periods of incarceration in the federal and state systems. Second, while facial recognition has the capacity to be highly accurate under ideal conditions, there is greatest cause for concern about accuracy when used in criminal investigations. And third, that the criminal legal system is not itself well designed to screen out mistaken or unreliable fruits of facial recognition technology. To begin with the first point, facial recognition technology does lead to deprivations of liberty. Courts do not currently admit testimony or other evidence of facial recognition matches to establish that a defendant is the perpetrator of a crime. However, evidence of facial recognition matches has been relied upon by courts in stages of criminal cases that are not governed by rules of admissibility. For example, in bail hearings to support decisions ordering pretrial detention, and in sentencing to find facts that enhance a defendant's sentence. Perhaps more critically, the overwhelming majority of criminal prosecutions begin and end with no presentation of evidence before a jury at all. I refer, of course, to the nearly 98% of federal criminal convictions obtained through guilty plea. In those cases, and given the designedly low evidentiary threshold of probable cause to arrest, facial recognition generated matches can generate a criminal conviction without any courtroom testing of the government's evidence. Moreover, even when facial recognition is used by law enforcement only to generate an initial lead, that early facial recognition match has the potential, particularly given the stickiness of cognitive biases and the very real potential for facial recognition matches to influence subsequent identifications, as Professor Friedman indicated, the capacity to send investigators down an erroneous path that, even if ultimately corrected, has enormous consequence for a wrongly accused individual like Mr. Williams. The fact that facial recognition is shaping outcomes in criminal investigation and adjudication would be of little concern if there were no reason to question its accuracy as a means of identifying suspects. But as others have already noted today, despite significant advances, significant concerns remain about facial recognition's accuracy. There are at least two reasons why the criminal investigative context raises special worries. First, as has already been discussed, the fact that there is significant variability in accuracy among facial recognition vendors, paired with the disturbing GAO findings that federal agencies rely on a wide variety of, and sometimes unknown, facial recognition systems, points to an urgent need for disclosure of, and perhaps restriction on what public and private facial recognition systems are being used. Second, aside from variability and disparity in accuracy across algorithms, law enforcement use of facial recognition to identify criminal suspects raises special accuracy concerns because it is particularly likely that less than ideal images will be used in such procedures. Studies of facial recognition that find low error rates do so only when using cooperative staged images. Declines in accuracy are consistently seen when using images not captured under ideal circumstances, precisely the types of images that are used in criminal investigations. Finally, none of this might give rise to a need for legislative intervention if the criminal legal system already possessed adequate means to police investigative use of facial recognition. It does not. Partly this is due to the fact that as long as facial recognition matches are used as investigative tools and not relied on as evidence in a criminal case, there's little opportunity for a defendant who's identified to challenge that practice in court. Additionally, however, restrictive discovery, the sharing of case information between the prosecution and defense, means that defendants are severely hobbled in litigating law enforcement use of facial recognition. In contrast to the regime in an increasing number of states, defendants in federal criminal cases do not have access to the government's investigative file. Indeed, defendants might not even learn that an early facial recognition match procedure was performed. Moreover, the trial-based timing of disclosure in federal criminal cases means little opportunity exists for the defense to vet the reliability of government evidence before entering a plea. And additionally, to date, defense claims that they are constitutionally entitled to information about facial recognition under the holding of the case Brady versus Maryland have gained little or no traction in courts. In sum, facial recognition is an alluring forensic tool with potential to accurately open otherwise unavailable investigative avenues. Troublingly, the federal criminal legal system is not well designed to smoke out questionable uses of the technology. I look forward to your questions.
Thank you very much, Professor, for your testimony. Now I recognize Mr. Brett Tolman for 5 minutes. Mr. Tolman, you're recognized. Thank you.
Thank you, Chair Jackson Lee, Ranking Member Biggs, and members of this subcommittee. Thank you for the opportunity to testify today. My name is Brett Tolman. I'm the Executive Director of Right on Crime, a conservative organization dedicated to the promotion of criminal justice policies that promote public safety, individual liberty, and whole communities. I've previously served as United States Attorney, as a federal prosecutor, and as Chief Counsel for Crime and Terrorism for the United States Senate Judiciary Committee. The first issue to address is a concerning lack of transparency and basic information relating to law enforcement's use of facial recognition technology. Many of the fundamental questions that you likely want and deserve answers to are currently unanswerable. Questions, simple questions such as how many law enforcement entities use facial recognition? How often do they use it? Who is in their databases and why? Beyond those federal law enforcement agencies one might suspect of using facial recognition, like the FBI, there are a host of others with less apparent need who also use the technology. For example, the US Fish and Wildlife Service and the Internal Revenue Service. Also discomforting are the sources of the photos supporting this technology. For example, the government utilizes millions of photos of law-abiding individuals collected from driver's licenses and passports. But private technology companies that contract with law enforcement have harvested billions of photos posted by unsuspecting users on platforms such as Facebook, YouTube, and even Venmo. This collection is an unprecedented invasion of privacy that places enormous undue control in the hands of the government and big tech, two entities not always known for their light touch or responsible use of power. Walking out the door in the morning can be an exercise in skipping from one camera to another. To this perpetual passive surveillance, law enforcement can potentially add recordings from body-worn cameras and the smartphone in an officer's pocket. In short, there are very few instances where law enforcement will not have the opportunity to subject a person of interest to facial recognition technology. Inevitably, the first temptation will be, and has been, to use facial recognition by default rather than necessity. Instead of limiting the practice to serious public safety risks or only after due process has been afforded, an individual, officers may use and have already used the practice for run-of-the-mill interactions in minor cases. Our founding fathers deliberately and prudently enshrined in the Bill of Rights prescriptions on the wanton search of Americans as a necessary bulwark for freedom. It is hard to square those notions and protections with the unfettered use of a technology that can instantaneously reveal an individual's identity as well as potentially their association and prior movements. The unrestricted use of facial recognition bears little difference to allowing police to collect fingerprints or DNA from anyone and everyone they come across, an abuse that we clearly do not and should not tolerate. Furthermore, we cannot ignore the risk that facial recognition technology will be used to target certain Americans. Facial recognition can instantly strip away the anonymity of crowds and ultimately threaten our constitutional rights of assembly and association. Consider the chilling effect facial recognition could have if used to identify individuals at a political rally or a government protest. This practice grossly lacks accountability. Right now, we have little more than vague assurances that we should trust the government to safely use the incredible power of facial recognition technology without such information or oversight. Not long ago, I was tasked with leading the effort in the United States Senate to reauthorize the Patriot Act. We heard similar assurances years ago by those leading the Department of Justice and the FBI about FISA and those surveillance authorities not being turned against honest Americans. We have seen how that worked out as outlined in the recent and disturbing Inspector General reports. None of this is to say that law enforcement should never have access to facial recognition technology. While China's unconscionable use of facial recognition technology to enhance and accelerate its undemocratic control of its citizenry is a warning of the costs of failure, I do not believe it is an inevitable consequence of any use of facial recognition technology by law enforcement. Further, it is unrealistic to expect law enforcement officials to permanently deny themselves a tool that is increasingly prevalent in the commercial sector and which has such powerful capacity to improve public safety. It is easy to contrive a scenario in which we would very much want law enforcement to have this technology. Searching for a known terrorist loose in our cities presenting an imminent risk to the public, or seeking to identify a mass murder suspect, for example. However, acknowledging there are credible uses for facial recognition technology and voicing support for law enforcement is not the same as writing a blank check for power and then looking the other way. If nothing else, we need a reset in which law enforcement agencies must gain affirmative permission from relevant democratically elected representatives to use this technology prior to its use. That way, transparency, accountability, and proper use guidelines can be established. I look forward to answering your questions.
Ms. Tolman, we thank you for your testimonies. Now, my pleasure and privilege to recognize Dr. Cedric Alexander for 5 minutes. Dr. Alexander, you're recognized.
Thank you, and good morning, Madam Chair, and those who are ranking members and subcommittee members for the opportunity to be here with you. And I hail from the great state of Florida, Pensacola more specifically, so it's great being here with you. I'm going to try not to be redundant because maybe some of what I'm going to say has already been mentioned in the time that has been allocated. But let me start by saying this. On July 9th, Portland, Maine Press Herald reported on 2 newly enacted laws that make Maine the first U.S. state to enact a broad ban on government use of facial recognition technology. In Maine, state, county, and municipal governments will not be allowed to use any sort of FRT. Law enforcement may use the technology for investigating certain serious crimes, but state law enforcement agencies are barred from implementing their own FRT systems. They may request FRT searches from the FBI and the State Bureau of Motor Vehicles in certain cases. A year earlier, in August of 2020, the Portland City Council totally banned the use of facial recognition by the police. Indeed, currently, there are approximately 24 American cities that ban police FRT use, and many other organizations has called for a nationwide ban because of evidence that false positive identification in the case of people of color exceed the rate of whites. So far, the federal government has enacted no law on how law enforcement may or may not use facial recognition technology. The benefits of facial recognition systems for policing are quite evident. Some have already been mentioned here. It is in fact that technology that does aid in the detection and prevention in crime. For an example, facial recognition is effectively used for issuing identity documents and is usually combined with long accepted biometric technologies, such as fingerprints and iris scans. FRT face matching is used at border checks to compare the portrait of digitized biometric passports. And FRT, as we all know, was used to identify suspects in the January 6th violent breach of the US Capitol. And high definition digital photograph and videography, sometimes deployed from aerial drones, may be used increasingly to identify faces in mass events. Currently, the FBI is a leading law enforcement agency that uses FRT, and it has developed technology and best practices to promote the intelligent use of technology to reduce error and protect constitutional rights. In addition, the Facial Identification Scientific Working Group, operating under the National Institute of Standards and Technology Organization of Scientific Area Committees, is working to develop standards for facial recognition technology. Facial recognition technology has been useful in law enforcement. I believe will continue to develop technically and therefore become even more useful. Blanket bans on FRT in policing are unwarranted and denied to police agencies a tool that is important to aid in public safety. But make no mistake, there are urgent constitutional issues relating to privacy, protection from unreasonable searches, due process, and the presumption of innocence. Especially concerning are false positives and negative identification results. In addition, police do not always use FRT correctly. For instance, on May 16th, 2019, the Washington Post reported that some agencies use altered photos, forensic art sketches, and even celebrity lookalikes for facial recognition searches. In one case, the Post, Drew Harrell, wrote, New York police detectives believed a suspect looked like the actor Woody Harrelson. So they ran the actor's image through a search, then arrested a man that system had suggested might be a match. Forgive me for being blunt, but that was pretty egregious, quite frankly. Using artificial technology to confer upon a highly subjective visual impression, a halo of digital certainty, is neither fact-based, prudent, efficient, or just, but under federal law, at least it is not illegal. It is not illegal for the simple reason that no federal laws govern the use of facial recognition. I'm going to stop here and be more than glad to answer any questions that you may have, particularly from a very practical perspective as being a former chief in 2 major cities in this country and a former federal security director for the U.S. Department of Homeland Security in Dallas, Texas for 5.5 years. So I understand the importance of this technology, but I also understand how it could be easily abused if those are not properly trained, certified, and the utilizations of best practices are not evident. So thank you, Madam Chair.
Dr. Alexander, thank you. And thank you to all the witnesses. We obviously have opened up in the parochial and often used term non-legal, a can of worms that we need to certainly address. And we will now be able to proceed with members' questions. And I'm very grateful for the attendance to all of you members, both on the minority side and as well on the majority. We will now proceed under the 5-minute rule with questions. I will now begin by recognizing myself for 5 minutes. Director Goodwin, you obviously know of the report, the GAO report 2019, indicating that facial recognition algorithms tested accuracy in a real way by race, ethnicity, or country of origin, as well as gender, and it differed in accuracy. What are some of the concerns related to facial recognition system accuracy? Director?
Thank you for that, Madam Chair. So a number of concerns that we raised in our report around accuracy, and I'll just focus on one main one. So just in terms of, if you think about a person's face, it's distinct, it typically doesn't change. If a person's face is, that information is breached or hacked, that is totally different than your password being breached. Well, you can change your password, but you cannot change your face. So in the report, we note this particular concern. The misidentification based on a facial image is of great concern, and we note that in our report.
Thank you very much. Mr. Williams, you were wrongfully arrested in front of your wife and daughters, detained for 30 hours in a filthy, overcrowded detention center because of facial recognition. Your story is stunning, and particularly holding up a picture alongside of your face. Your good comment, do we all look alike? You were a suspect allegedly in a theft investigation. Prosecutors dropped the charges, and the Detroit police chief apologized for sloppy detective work. Tell us, what impact did your arrest and detention have on you and your family? You're obviously a gentleman with an employment, a family. How did that impact you?
Well, thank you. But well, the first thing when I came home, or was on the drive home, my wife was saying how she had to figure out how to get in contact with the detention center because they kept hanging up on her and telling her they can't answer any questions because they don't have any information. All they know is that I'm there, and that's all they can tell her. And when I got home, I asked my wife what was going on, and my daughter had took pictures of family pictures of us and turned them around because she said she couldn't bear to look at me while I was in jail. And I had to go talk to a 5-year-old at the time about a mistake that had been made by the police, and it was hard to make her understand that, sometimes they make mistakes because you tell her as a child that the police are your friend, and if you ever get in trouble, this is who you go to, and this is who's going to help. And it was, I had to deal with that, and we've thought about even taking her to a psychiatrist because when we replay the video from what happened, she can't stand to watch it. She gets all emotional, and it's understandable. And I just have to go through that. I mean,
Painful. Thank you so very much. Thank you so very much. Professor Friedman, you've heard that story. My time is short and I have 1 or 2 other questions. What are the privacy implications and risks to communities if a private company has access to the details of law enforcement investigations? And you might add your thought about a legislative fix or thought about how we address this question. Professor Friedman?
Thank you, Chair. That was an incredibly moving story. I have kids and I can only imagine. The problem, as I think Mr. Alexander pointed out, is that the use of this technology is a bit like the Wild West. There's no regulation. And when there's no regulation, we're going to have mistakes and we're going to have breaches and we're going to have all kinds of trouble. And there are uses of the technology for law enforcement, but we need a full set of regulations. And I've set out a bunch of them in my testimony. I think you could do a lot of this by regulating the vendors directly as a product moving interstate commerce. You could set a number of standards, including that the companies themselves have to regulate and identify what are effective probe images, what are the right size of the databases, what are the thresholds to avoid false positives and false negatives under different circumstances, that the technology is self-auditing so that we could know how it was used by law enforcement. So there's a lot of things that could be done.
Thank you very much. Dr. Alexander, what are your suggestions on how law enforcement authorities can reduce the phraseology that the Detroit chief had to acknowledge sloppy detective work greatly without greatly reducing investigative efficacy? Dr. Alexander?
Thank you, Madam Chair. I guess if having been a former chief and I had to respond in that way, that would certainly suggest to me that I have a larger systemic issue around way investigations are conducted and how people are interviewed. Here's the issue though for me. The technology is one in which we use every day. We pick up our cell phone, we use it to access calls or text messages, whatever the case may happen to be. The biggest issue here for me, and will continue to be, when you have victims such as Mr. Robert Williams, people who are innocently going along their way because of a failed ability for us in policing, quite frankly, and I say we because I have been there, the inability to train people appropriately. They have to be trained, there has to be certifications, there has to be best practices, and there needs to be certification, both, I believe, certainly at a state level and a federal level, that has to be ongoing. Because one thing that we know currently is that we don't train enough. But when you are utilizing that type of technology that can easily infringe upon someone's Fourth Amendment rights, I think we have to be very careful. But we also have to remember where we came from, even in DNA technology, where we there too have seen over the years, particularly in the past, we've seen DNA labs that were shut down because of people's inability to carry out that professional function based on certification and accuracy. And we don't want to find ourselves using this technology doing the same things that we have done in the past, because what it will continue to do, Congresswoman, is drive that proverbial wedge even further apart between good policing and communities across this country. And I don't think that's a road we want to continue to go down.
Thank you so very much. My time has expired. I know that there are many other questions that I have interest in, but let me yield to the ranking member of the subcommittee, Mr. Biggs, for 5 minutes.
Thank you, Madam Chair. Ms. Goodwin, thank you for being here today. In your most recent report, you found that 13 of the 14 agencies that you surveyed that reported using non-federal systems did not have complete, up-to-date information about what systems their employees were even using. Is that a correct interpretation?
Yes, that's correct, sir.
So in fact, if I understand right, even one of the agencies you worked with had to poll its employees to see whether they were using the system and what systems they were using. Is that accurate too?
That's correct, Congressman. And then one of the agencies polled, they initially told us that they didn't use the technology. And when they polled their employees, they found that the technology had been used in over 1,000 searches.
Well, if agency leadership does not even know what systems their employees are using or whether they're using it, how can they be sure that those systems are not being misused and that our constitutional rights of American citizens are not being violated.
So this speaks to the heart of the recommendations that we made, that agencies, have an awareness. It's important that they have an awareness of what systems they're using, particularly the non-federal systems that their employees are using. Given that awareness, then they can then begin to ensure that the appropriate protections are in place related to privacy and accuracy.
Ms. Frederick, we know federal agencies are using private searches, and they're collecting literally billions of images. How are those images acquired?
Well, it depends on the private company. A lot of these companies, Clearview AI was mentioned earlier. They claim to scrape the internet, social media sites, things you might upload, what your grandma is still using Flickr to upload. There was an IBM scandal there as well. So they're basically just scraping what is publicly available on the internet when people are unwittingly uploading these photos, clicking yes to some of the terms of use on these private companies. They're not consenting to allow these images to be used by law enforcement, but by using those non-federal private companies, these contractors like Clearview AI, like Babel Street has been mentioned, they are just using your regular photos from your grandma, from your family, from your sisters, from your daughters. So it is pretty much a government-infused Wild West out there.
Mr. Tolman, these systems, these private systems, let's leave off federal systems for a moment, but our law enforcement systems, what steps are they even taking to secure their systems?
Well, the reality is they're more interested in the dollars that are behind this technology than they are securing civil liberties. And that will always be the case when private companies are contracting and utilizing a powerful technology. Their interest is going to be driven by their bottom line.
So, Mr. Tolman, back to you still. These agencies, like federal agencies that are using private services, what is it just easier for them to contract out than to develop their own system, I assume?
Yeah, the capability is, hundreds of millions of photos versus, what they would be able to gather themselves with limited staff and resources.
So how are we going to ensure that Americans are not being targeted by federal agencies using this facial recognition technology? What are your policy prescriptions?
So there certainly is, as others have said, there is going to have to be a complete shift, meaning the legislature is going to have to enact regulations that require any agency, government agency, whether they're contracting or not with big tech or other companies, are going to have policies that allow for the proper use, the legal use of this, ones in which you all say is a legal use. I prosecuted the kidnapper of Elizabeth Smart. I can imagine during that case, when I was a prosecutor, we would have clearly sought out law enforcement's ability to use that to identify Elizabeth and to try to find her. That's a far cry than just downloading all from social media what you can and then targeting others without the legal justification or the regs or policies that have been approved by Congress.
Mr. Lee, I'm going to ask you the same question. What policy prescriptions do you advocate that we can ensure that Americans are not being targeted by federal agencies or other law enforcement agencies?
Ranking Member Biggs, thank you for the question. The Leadership Conference supports a ban or a moratorium on the use of these technologies. We support a ban or moratorium because one, these communities are already, the communities where facial recognition technology is being used are already over policed and over surveilled. Two, facial recognition technology is disproportionately inaccurate for Black and Brown communities, and particularly communities of color. And three, the community has not been involved in these processes. The Congress is not engaged in legislation on these topics. Communities have not been involved in highlighting what they think policing should be, specifically within the context of facial recognition technology.
Thank you. My time's up, Madam Chair. Thank you.
Thank you very much. Now, pleased to recognize Mr. Nadler, Chairman of the committee. Mr. Nadler,
Thank you, Madam Chair. Direct use of facial recognition technology In your report, you found that 15 agencies reported using systems owned by another federal entity, and 14 reported using systems owned by state, local, tribal, or territorial entities, including the FBI. Can you briefly describe for us how the FBI uses state systems to expand its facial recognition search capacity?
Thank you, sir, for that question. So I'll briefly talk about how the FBI used the technology around the events of January the 6th. So the FBI has a media tip line that I'm sure you're aware of. And so what they did, they asked for people to submit images to the media tip line. The images that were submitted to the tip line, they then inserted into an FRT system to try to get some potential matches. So that's one way the FBI has used the technology. And we did a report a few years ago on FBI specific use of the technology. And we had issued a number of recommendations that spoke to them complying with the privacy impact assessment, otherwise known as the PIA, and the systems of record notice, otherwise known as the SORN. The FBI ultimately, they agreed with our recommendations and they implemented the recommendations. And so they have, I think it was Mr. Alexander, Dr. Alexander, who mentioned that the FBI has done a number of things to ensure that the accuracy of the FRT systems that they are using has improved.
Thank you. And also, Director Goodwin, the report describes how agencies use non-government-owned systems. What are the potential security risks associated with a federal law enforcement agency using a non-federal government-owned or even a state or local government-owned FRT system?
So I'll focus on the non-federal systems, and it's something we speak to in the report. As I mentioned earlier, the privacy impact assessments and the systems of record notice, the PIA and the SORN, those are two standards that typically, if a government agency is using their own system, they have to follow. And so the concern that we mentioned in our report is that if they're using a non-federal entity for facial recognition technology, that non-federal entity may or may not have to comply with the recommendations and the guidelines laid out under the PIA and the SORNs. And so that's a concern. And so with the PIA, that, of course, speaks to how the images are being used. The SORN speaks to the fact that if there's a change in the technology, that information has to be made public and available.
Thank you, Professor Lauren. For those who are arrested following law enforcement officers' use of facial recognition technology to match them to a suspect's photo, what protections are in place for defendants who are presumed innocent at that point to challenge the use of the facial recognition technology that led to their arrest?
Well, in many instances today, it's quite limited, the opportunity to do that. In fact, practically non-existent, to the extent that the practice has been for law enforcement agencies to use the facial recognition match as a lead that then is sort of corroborated through other evidence. The risk, though, is that that corroboration ends up not truly being independent corroboration. So, for example, in a case in Florida, a facial recognition match was made based on an image in a store, and subsequently a police officer who knew that the match had been made looked at the image himself and said, yeah, these two guys look alike. So, right, already knowing that the computer had assisted a match sort of doubled down on it, which is not an independent corroboration. And what courts have said is that defendants really don't have the right to challenge the facial recognition match when the government isn't relying on it in court. But that misses the fact that that match could taint what is showing up in court.
Thank you. Facial recognition systems have been found to be less effective at detecting people of color and women. As we heard from Mr. Williams, he experienced this technological flaw in real time when he was misidentified despite his photo not resembling the suspect. Professor Friedman and Mr. Lee, can facial recognition technology be incorporated fairly into criminal investigative and public safety strategies despite this inherent flaw in the algorithms? Professor Friedman?
Bert, go ahead.
First of all, Chairman, it's a pleasure to see you again, especially under these circumstances. And secondly, the Leadership Conference does not. Currently, the issues of accuracy alone would say that would hold that a ban or moratorium would be the most appropriate use. But in addition, these technologies are being used in communities that are already over-policed and over-surveilled. And so there is no way to get around the accuracy and over-surveillance issues that come with law enforcement use of facial recognition technology.
Mr. Lee?
Chair, so I want to echo the grave concern about technologies that have these demographic differentials. I've said in the past that they ought not to be used unless that can be addressed. I actually join Mr. Tolman in thinking strongly that we shouldn't be using the technologies until there's regulation. There may be ways to deal with the demographic disparities if we understand what they actually are, but we don't have that testing, so we have learning to do. And then we have to think about what it means to have a human in the loop, because many people offer that up as a way to ensure that these things don't go wrong. But as Mr. Williams' story all too graphically demonstrates, the way we use humans in the loop right now don't do that. It might be possible to develop protocols and best practices to do that, but we have not made that happen yet. And that's why we so desperately need regulation.
Thank you, Madam Chair. Before I yield back, I ask unanimous consent to place the following into the record. The statement from over 40 civil rights groups, a letter from the Security Industry Association, and individual statements from Data for Black Lives, the Electronic Frontier Foundation, and the Project on Government Oversight.
Without objection, so ordered.
Thank you. I
very
yield
much.
back.
Thank you very much. Mr. Chavit, you're recognized for 5 minutes.
Thank you, Madam Chairwoman. I'd like to lead off by thanking our ranking member, Mr. Jordan, for allowing me to go in front of him. I have a noon speech that I'm supposed to give in my district. It's going to take me a while to get there, so I really do appreciate him switching spots with me here. In addition to being a senior member of the Judiciary Committee for quite a few years, I also serve on the Foreign Affairs Committee, and I'm the ranking member and past chair of the Asia and Pacific Subcommittee. And in that capacity, we, both Republicans and Democrats on the committee, have been very closely watching, observing, monitoring what the PRC and the Chinese Communist Party is up to there, and the threat that they pose not only to Americans, but to their own citizens. And it's well known, as was mentioned earlier, I think in the statement of one or two of the witnesses, that the Chinese Communist Party uses a vast civilian surveillance network to track nearly every movement of every single person there. And there's 1.4 billion people who they're tracking. So it's a pretty extensive effort that they've undertaken. For example, they force their citizens to download apps that monitor them. They track social media posts to look for what they consider to be negative content. They stop people at random to check their devices for apps deemed to be dangerous to the state. And they use facial recognition technology similar to what we're discussing here today to pick individuals up that they're looking for in crowds. All of this is it's in order to build a so-called Great Firewall between China and the rest of the world, so they can keep their people under control and to gather personal data on their citizens, which can be used to flag and potentially torment the people of China, individuals they believe are going to be unhelpful to the regime. So I'd like to ask Ms. Frederick and Mr. Tolman, would you care to comment on the assessment you see relative to China, their use of facial recognition, other technologies to monitor their citizens, and how the CCP is using facial recognition technology to oppress individuals and certainly various groups? The Uyghur community comes to mind because they've obviously been in the news, not nearly enough of late when you consider that 1 million people are in their gulags. And are there any lessons that we should learn from this? And I'm not by any stretch of the imagination suggesting that our government has anything like this in mind. But I'd like to hear from those two if we could.
Certainly. Thank you for the question. I'll begin, if you don't mind, Mr. Tolman. This is, we should say, yes, we have a system in the United States here that matters, sufficient rule of law protections, openness and engaged citizenry, a free press, and an independent judiciary that act as guardrails for now against the propagation of technology for political ends that are anywhere near like China. But it is important to look to them, as I said before, they're the bleeding edge of using these technologies for internal control and internal stability. They pervade a path for ethnic targeting in the western region of Xinjiang, as we talked about, where 1.5 million Uyghurs are imprisoned in re-education camps, often through the use of these facial recognition systems. But it's not just about facial recognition alone. I think the ability to integrate seemingly disparate data sets as they do in Xinjiang, they use something that Human Rights Watch has reverse engineered. It's called the Integrated Joint Operations Platform. And what they do is they take all of this data, they fuse it. It's license plate readers, data doors, these things that pick up SIM cards and all kinds of biometrics, iris scans, just all the digital exhaust that we're constantly emitting, that people even in these regions are constantly emitting. They put them all together and they use this information. They use new technology, artificial intelligence. This is one of the first places that they started using it for political identification of dissidents, of Uyghur minorities. What I see coming down the pike is the use of DNA phenotyping. China's already trying to do this. They're trying to use an individual's DNA to predict what their faces will look like. They are experimenting with voice recognition technologies. And the idea is to combine all of this into this digital panopticon and use it for basically an iron hand of digital control. And we have the technology right now to do so. They've visited some of this in Hong Kong, as we've seen the diminishing of freedoms there. You know, how does a democracy die in full view of us? And China is using technology in order to enact it. We know that Russia is doing the same things when it comes to pro-Navalny protests in January of this year. So all of these things are something to keep in mind. And as Paul Moser from the New York Times said, which I think is something that I would lead you with, is what China is trying to do is totalize control. They are trying to link digital reality with physical reality, and that chasm that used to exist is growing closer and closer and closer together. China wants them to be completely interconnected. We have to guard against that here in America.
Thank you, Madam Chair. My time's expired. Perhaps Mr. Tolman could respond in writing, just so we don't hold the committee up at this time.
Thank you very much, Mr. Chapman, for yielding back. I now recognize the gentlelady from California, Ms. Bass, for 5 minutes.
Thank you, Madam Chair, and let me thank the ranking member and our witnesses for being with us today. I wanted to know if the witnesses, either anyone could speak, could distinguish between using facial recognition to investigate versus facial recognition for arrests. And is it more productive to use it that way versus all of the complications for arrests? Also, you know, it's very well known, and it's been said by numerous panelists and members of the challenges of facial recognition with people of color. But I'm not sure, unless I missed it, if anybody said, does it work better if it's white men? How does it perform? Mr. Alexander, would you like to go?
Well, I'll try to respond, I think, to the first part of your question, whether the technology should be utilized with the idea of making an arrest based on the identification itself, or can it be used as an investigative tool? When I think about it as an investigative tool, if that person image happened to be a match or a similar match, and we're working with 0 leads in a case, it may be proved to be of some value, right? the thing we have to be very careful of, and I think someone mentioned it earlier and articulated it far better than I can, is that we have to make sure that we cognitively don't approach that individual already with our implicit biases in mind that they are the exact person we're looking for. You follow what I'm saying, Congresswoman? So I think we have to be very, very careful with that. But ideally, to be perfectly honest with you, I was here 2 years ago under the leadership of another hearing with late Congressman Elijah Cummings, having these same conversations. And I recollect very clearly, there was a woman there who was a professor researcher at MIT who spoke very elegantly around these issues and was able to provide some insight in terms of the depth of this technology and how it does not work to the advantage of people of color and women. But there is an overwhelming amount of evidence, and I think there are those on this panel who can talk further about this, where in the case of white males, there was least likely opportunity for misidentification, but certainly those of color and women, it tend to be more problematic.
So you said least likely, meaning that it's more accurate with white men? Is that
Oh, yeah, yes, it's more accurate with white men. I'm sorry. Yes.
And,
Yes.
and maybe someone else could respond to that. I don't know if it's Mr. Friedman or Ms. Goodwin. What about that in terms of the accuracy and also its use as an investigative tool? In the George Floyd Justice and Policing Act, we essentially say there should not be federal resources in facial recognition. Mr. Williams, you have your hand raised.
I was just going to say about the question you had previously asked, that it was supposed to be used for an investigative tool at that point, and they came and arrested me and didn't even tell me anything. I don't even live in Detroit. In Detroit, police came to my house in Farmington Hills and basically carted me off. Right. So I don't really have a lot to say about that. All I'm saying is the way that it's used, they're not doing any due diligence at all. There was like the chief said, it was a shoddy investigative work done.
And actually, excuse me, Mr. Williams, to me, you're an example of what I wasn't saying. In other words,
I was talking about you asked the question.
Right. They used it for your arrest, which
Right.
I think is clear as problematic, but I was referring to using it to investigate, not in real time, for an arrest. Mr. Friedman, do you have anything you want to say in the last few seconds?
Sure. I think there are things that this body could do regulatorily, and then there are things that it could learn and try to get us to learn. And one of the problems we have is that NIST has not tested the kinds of uses that law enforcement is using. And what we need, and I'm happy to elaborate, but I don't want to go over time, is the kind of testing that actually reflects what's happening in law enforcement use rather than a set of kind of abstract possibilities for the accuracy and bias.
Thank you, Madam Chair.
Thank you so very much, Mr. Ranking Member. I'm not going to take up your time, but I'm just moved to say it appears like unreasonable search and seizure under the Fourth Amendment. But I will not take up your time, and I'm delighted to recognize Mr. Jordan for 5 minutes.
Thank you, Madam Chair. Let me go to Mr. Tolman. How often does it happen? How often do we get the wrong person? Where Mr. Williams told his compelling story of how they were just wrong, and he was arrested and detained, I think he said, for 30 hours. So, I know the Huber family, the recent story of the couple in Alaska who were not in the Capitol on January 6th, but their door kicked in, they were put in handcuffs, they were at gunpoint at one point in during the interrogation. It was like a 4-hour interrogation. So I just and it was all based on facial recognition. So how often do we get the wrong person?
Well, one time can be too many, but certainly some estimate as high as 30%, but I actually believe it's more than that, Representative Jordan. And it's nice to see you again, sir.
You too,
It is, I believe, higher than that. I have represented two individuals, one of whom I'm fairly certain, and it's not, we don't know about the ones that aren't publicized or the ones that, are coming forward, but I have a client who was, accused of going inside of the Capitol. He was not in the Capitol. I believe it was facial recognition technology that put him in law enforcement's, investigation. And we certainly had to work backwards to show that he was not. And so I think it's more often than we know because it's not being reported.
Is Mr. Lee, do you know, is there any kind of, Mr. Tolman said 30%, is that, and we know there's a disproportionate impact on African Americans. Do you think it's a higher number than that, or is that probably where it at 30% of the time this technology gets the wrong person?
Ranking Member Jordan, thank you for the question. We don't know, and that's a part of the problem. These technologies lack the requisite transparency and the requisite oversight for us to even know. Of the cases like Mr. Williams that we do know, those are terrifying. But what about the cases that are maybe on a nice edge that we don't know about right now? And so we do need more transparency and more oversight, specifically with facial recognition technology and its use by law enforcement.
Yeah, thank you. I'm going to yield to our ranking member, but I mean, I'm concerned in a general sense that just the overall surveillance state and individual Americans, just fundamental liberties, fundamental rights. But when you add on top of that, the fact that it's wrong so often, to me, this is why if we can't come together in a bipartisan fashion, as I know we've been trying now for a couple of years, if we can't do that and figure out a way to put restrictions on this, limit this, particularly when you have all these agencies using the technology, they don't even know which technology they're using and whether it's private or what have you. I mean, there's just a host of problems here. So I appreciate Chairman Lee having this hearing, and I'm going to yield the remaining 2 minutes to our ranking member, Mr. Biggs.
I thank the gentleman for yielding. And my question this time is to you, Ms. Frederick. Peachtree Corners, Georgia used AI-driven smart cameras to monitor social distancing and use of masks during COVID-19. With current technology, what prevents federal agencies or state and local government from using facial recognition, not just to use it for identification, but to track movement and behavior of law-abiding citizens?
I fear that's what's coming down the pike. And, right now there are specific transparency measures and, lukewarm, I would say, strictures on some of these uses. Ms. Goodwin talked very well about the PIA and SORNs and GAO's recommendations. Those are great start points, but at this point, there are no hard constraints on the expansion of a remit for these cameras. So the public safety remit, it's huge. It could encompass all sorts of things. And clearly certain municipalities are taking advantage of that to interpret public safety as they wish. So unless federal entities are required to really submit those efficacy reports, those transparency reports that don't yet exist in a very rigorous fashion, then I fear many official entities will be allowed to interpret the use of facial recognition, interpret the use of digital surveillance in any way they can. And I will say quickly, when I was at Facebook, the ethos of private companies and shipping these products, and this is the problem with private companies being used by federal entities, is you want to ship it. You deploy these technologies as fast as you can and solve problems in the rollout in later iterations. That ethos is in direct conflict.
So, Ms. Frederick, thank you for answering that. I need to ask one more question because it deals with, and I want to talk to Professor Lauren real quickly. She had her hand raised with regard to the question on investigation versus arrest. And what has come to my mind is this notion of tainted photo lineups, tainted identification being used in investigation as predicate for making an arrest. Did you want to elaborate on that, Professor Lauren?
Thank you so much for the opportunity, Mr. Ranking Member. I will say just a bit more, and that's to say that I do think that it's possible in theory to think about a distinction in the use of the technology as an investigative tool versus forming the basis for an arrest, or put differently, a facial recognition match by itself forming probable cause, right, to arrest. But I think that from a regulatory standpoint, one needs to take great care in thinking about what strictures need to be put in place to create a meaningful distinction between those two things, right? So, for example, there are a number of agencies that currently say facial recognition itself cannot be the basis for probable cause. But then there are very few, if any, sort of strictures around what further investigation is required to build an independent case, right? Are there, for example, blinding procedures so that individuals who are then doing a subsequent lineup don't know that facial recognition initially matched the individual? If not, right, that's not a particularly meaningful independent check. And the last thing I'll say is that I think there's an important sort of intersection here between facial recognition technology and what we already know about the fallibility of eyewitness identification, right, which in over 75% of known DNA exonerations, there were now known to be wrong eyewitness identifications that occurred. So that's an investigative tool that itself is already quite fragile, right? And when used as a corroborating piece of evidence with the fragile facial identification, that should give reason for concern as well. So thinking about what strictures need to be in place to create a meaningful check on the investigative use of facial recognition is an important regulatory move.
And Madam Chair and Ranking Member Jordan, my time is long expired. Thank you.
Thank you very much. It is an issue that warrants a lot of involvement, and we thank our members. And I'm delighted now to recognize Ms. Stemmons, a gentlelady from Florida, who has a fellow Floridian on the panel for 5 minutes. Ms. Stemmons?
Let me say good morning to all of you. Thank you, Madam Chair, and thank you, Ranking Member, for this very important discussion. Thank you to all of the witnesses for being here, but it is good to have a fellow Floridian on the panel as well. So thank you very much. As a former police executive, I'm always interested in new technologies that can help to keep the public safe, help to keep law enforcement safe, and improve the delivery of police service. And we know that we have work to do in all of those areas. It was a decade ago that we were testing body cameras at the Orlando Police Department. And while we weren't really sure of the road ahead, I do know that the public was very excited about that possibility. Certainly it is one of the recommendations that's coming to the forefront now. And so we should always seek technologies that will enable us to better do our jobs. Dr. Alexander, you said that technology has long outpaced attempts to govern it. And I think that is such a powerful statement, because not only does it appear that the use of facial recognition outpaced our ability to govern it, we see that with other technologies as well. But Dr. Alexander, you talked about some best practices until we can find ourselves at a point where we can keep up, if that will ever happen through regulation and other things. Could you just expound a little bit on some of those best practices?
Well, I think it, and thank you very much, Congresswoman Demings. I think it's very important for us to recognize that technology does move along very quickly. And if we think about the development and the implementation of technology over the last 10, 15, 20 years, or even last 5 years, it oftentimes outpaces us as human beings. We're not prepared oftentimes for the unintended consequences that comes with the technology that we're all utilizing every day in our lives. So yes, we have to develop best practices. And what are some of those best practices? I think we can really only clearly define once we make some determination about the real legitimacy of this facial recognition technology. Look, it can be innocently used with our cell phones just to open it up and conduct our personal business. But when it comes to the constitutional right of American citizens across this country, regardless of where they are and what neighborhoods they're in, that becomes more problematic. Can we use it as an investigative tool? You know as well as I do, Congresswoman, oftentimes we might embark upon an investigation where we have 0 leads. but maybe we have a piece of this facial recognition that suggests, could that be Cedric Alexander? What we can't do is what happened to Mr. Williams. We can look, well, let's look into the background of Cedric Alexander a little further. Let's explore some other things that we did not maybe even think about, even had a suspect at all or person of interest. But the problem even lies there, as I've already stated, is that sometimes we can identify an individual that may be a likely person of interest or suspect, but if our own implicit biases get in the way, it will overwhelm the entire investigation, and it leads us down this dark path of where now we're really doing injury and hurt to people. But here's the bigger thing I would mention to all of you in Congress is that as we go through this place in America right now around police reform, one thing we do not need is a piece of technology that is going to continue to drive a separation between police and community. People want good police. We all want great technology. The idea around this technology really is it's great, it's well-founded, but it has to become more accurate. It has to have the type of legitimacy, trust in this technology that is needed in order for the American people to feel like it's not going to infringe upon the rights and hurt people in any type of way. I sit on a National Innocence Project board, and I understand the importance of DNA technology and how it's used to free individuals, quite frankly, who should never have been incarcerated, like Mr. Williams. But we have to do a better job in advancing this technology, but understanding that sometimes the technology moves along faster than we do as human beings, because we still got a lot of catching up to do around many of the social challenges we have in our great nation. So I hope in some kind of small way that addressed your question, Congresswoman.
It did. Thank you so much again. Thank you to all of our witnesses. And with that, I yield back, Madam Chair.
Ladies' time, thank you very much. It's expired, and we now recognize Mr. Gohmert for 5 minutes.
Thank you, Madam Chairman. And I got to say, this really warms my heart to hear witnesses from both sides having so much good input. It was my observation during the Bush years that the Department of Justice was able to convince Republicans, many of them, a majority of them, no, we don't need any reform right now, and really push back and convince Republicans that were in charge to back off of some reforms we should have made. And I noticed resistance like that. I'm sure a lot of pressure from the Obama administration on Democrats that were in charge not to do some reform that was needed. So when I hear the testimony and the questions and hear this in such a great bipartisan way, something that is so serious, it really does warm my heart. Some great comments and great questions. Dr. Alexander, I note you're careful to make sure that, you note that this technology can be helpful. And then it sends me thinking back about our FBI. You think the technology on recording statements, instead of the FBI having their agents not record statements, audio or video, but just write down their version of what the witness, do you think the technology has gone too fast for the FBI, that maybe we could get them to start recording with audio at least, maybe video? And I am being sarcastic, but that is an area of concern for me. If you combine facial recognition mistakes with the FBI's ability to only write down what their version of what the witness says, you combine flaws like that, then we are looking at some serious problems at the federal level. local. I'm sure your law enforcement that over which you oversaw recorded statements, so that wouldn't be such a problem. But can you see regulations, Dr. Alexander, that would help us be able to confine facial recognition just to the investigative stage so that, and as a former judge, you know, I know sometimes law enforcement will come in and they'll go, now, Judge, this is, you know, in the affidavit, but, you know, hey, we did also, well, if you didn't swear to it, I don't want to hear it. But that discrimination of real sworn evidence to unsworn evidence isn't always distinguished by some judges. You see some regulations we could utilize to actually get some teeth into that?
Well, and thank you for that question, Congressman Goodwin. I think, first of all, let me say, I think the FBI has the tendency, has the ability, has the training, and also has the fidelity of federal law enforcement agencies that is well trusted. And everything that they have pursued, particularly around technology, they really kind of stood up on technology if you go back 100 years with them, in terms of the work that they did back then and they do today, forensically. But they do have great capability of being able to access that type of technology and use it in a way that is standardized, one in which they have best practices, one in which they are the leaders around the utilization, because they use this technology to go after foreign actors who want to do harm to this country, or to utilize this even in domestic cases.
Dr. Alexander, my time is short, but
yeah, but
I am very concerned about some of their abuses. And when we see the FISA court that meets in secret, and then there doesn't seem to be any checks. And like I say, as a former judge, I'm very offended that some judges have not been outraged, like Mr. Williams' treatment and others. I think that is a problem when the judiciary is not upset enough to actually take action and bring law enforcement into line. But let me ask Mr. Tolman, do you see a way to get specific regulations that would discern between investigation and actually going to court and getting a warrant and picking up somebody like Mr. Williams?
Yeah, I think you could implement things such as not allowing for the facial recognition technology to launch an investigation, that they would have to have independent basis to launch the investigation. And then ultimately, if it went to trial, you could utilize facial recognition technology as additional evidence, but you can't have it the other way around, because then you have concerns about whether the evidence that is corroborating the facial recognition technology is simply influenced by the subjectivity of the investigators.
Well, thank you. My time's expired. Thank you very much, Chairwoman Lee. I really appreciate this hearing.
Thank you so very much, Mr. Gohmert. We're more and more finding some common ground. Should be some good opportunities for us to move forward. I'm delighted to recognize now the gentlelady from Georgia for 5 minutes. Ms. McBath, you're recognized.
Thank you so much, Chairwoman. I really, really appreciate you today. And thank you to each and every one of you that is here today. And just thank you so much for all of your timely resource and information and your expertise. And I'd like to go ahead and just kind of start a really quick question. Dr. Alexander, looking at how we might regulate facial recognition technology, how can we seek to build trust between law enforcement and the communities that they serve, especially communities of color?
Yeah, well, fundamentally, that's where a lot of the issue lies, Congresswoman McBeth, because currently in this environment that we're in, and this is not new, it's just more exacerbated now over the last several years, there is certainly a great deal of mistrust between police and community. And anytime that you're already dealing with that in the current context of where we are right now in this country. But as we continue to introduce new technology and ways of doing things that are questionable, such as facial recognition, if we don't do it right and we end up with continued victims like Mr. Williams, then we continue to create that separation where legitimacy around policing continues to be questioned. And this is the fight that I find myself fighting every day in the roles that I play now, is really trying to build those relationships. But it certainly does have its challenges associated with them. But we got to get the technology right, because if we don't, it's not going to help the cause in building those relationships. Because if we don't have that collaboration between police and community, and I don't care where it is, we're going to continue to find ourselves here and continue, all of us, to continue to be at risk.
Thank you so much, and stay in the fight.
Yes.
And Professor Lauren, your testimony notes that the rules of discovery, the sharing of case information between the prosecution and the defense are restrictive. And so prosecutors don't actually have to mention what facial recognition technologies they might have used to investigate. And our courts don't get much of an opportunity to advance the law by sorting out what is acceptable and unacceptable uses of this technology. Could different kind of discovery rules help with this kind of problem?
Thank you so much for the question, Congresswoman. I think the short answer is yes. And just at the risk of going a little bit into the weeds, one thing to understand about criminal discovery in the United States, just like criminal law generally in the United States, is that there's tremendous diversity of systems, because we have, at least 51 criminal justice systems in the United States, given the states and the federal government. And so if you look across those systems, the federal criminal discovery is really among the most restrictive. Rule 16 is very limited in terms of what information the government is required to disclose to the defense. There are a number of states that have, particularly in recent years, gone quite, in the opposite direction. New York most recently, but my own state of Texas, in passing the Michael Morton Act, moved to essentially what's called an open file discovery system. And under that system, the defense typically would have access to essentially the entirety of the non-privileged, anyway, investigative file, would know the steps that investigators took, regardless of whether the prosecution was going to present that evidence, and regardless of whether a court deemed it to be exculpatory or favorable to the defense. So I actually think that, in addition to some of the points that Mr. Tolman was just making about regulations that one would want to have in place about how evidence could be used, that particularly in thinking about the federal system, that thinking about opening discovery more with regard to facial recognition technology is really an essential part of achieving transparency and really vetting the reliability of this in the course of criminal adjudication.
Thank you. In just a few moments I have left, Professor Friedman, should Congress regulate private and government-owned systems? I guess I know that the GAO report shows, as others have noted today, that facial recognition systems owned by the government, as well as those owned by private companies and used by government actors, aren't always regulated. Does the ownership of these systems play a role in how they are used?
Sure, thank you for the question. I think it's essential that there be regulation. In fact, I think you're hearing all of us say that it's essential that there be regulation. And the likeliest way for Congress to regulate is actually the vendors, the manufacturers of the product that are distributing them in interstate commerce. That's a constitutional hook to get at the regulation. And so I think it's essential. Now, you do want to regulate the use of those technologies by law enforcement agencies. There's been a lot of discussion about trust between communities and law enforcement, but you're just not going to see that until there's a serious set of regulations for how the technologies are used with very strong guardrails. Again, I could say more, but I see the time has expired.
Thank you so much, each of you, and I yield back the balance of my time, which there is none. Thank you.
Time has expired. Thank you so very much. I now recognize Ms. Tiffany for 5 minutes.
Thank you very much, Madam Chair. Mr. Frederick, I want to just frame my question with the background of the Biden administration is reported in the last couple of days to be coming out that they're going to enlist the wireless phone carriers to vet people's text messages. And I mention that because Some of my constituents believe we are a short leap to the Communist Chinese Party's use of technology in their country, where they've created their social credit system. Are my constituents right to be concerned about where we're at here in the United States?
Well, I'll say as somebody who worked in the intelligence community for almost a decade, I think your constituents are right to be concerned about where these technologies can take us. What I think is particularly disconcerting is what you mentioned, SMS content potentially being parsed. Email content has been mentioned as the next frontier. Podcasts have been mentioned as having a portion of unfettered conversations. You know, these are bastions that shore up our culture of free speech. I definitely think it is of concern to see where authoritarian governments are sort of taking us. Again, we have that system of guardrails, but it is important, especially for conservatives and those expressing heterodox views, to be vigilant and to watch where this technology naturally goes and guard against it. And I think we're all advocating here for certain guards in some respect.
Dr. Alexander, you mentioned the state of Maine, in particular Portland, Maine, and we also heard from Mr. Lee, commented communities have not been involved. Isn't there a role for city councils, state governments, those governments that are at the state local level to get involved with this because they're responsible for their police forces in all instances, correct? I think you're muted.
Yes, thank you, Congressman. Yes, you're absolutely right, because there at the local level is where it all starts. In local elected officials, mayors, city managers, county managers, whatever the case may happen to be, they certainly do need to have a voice in this, because what you want to always make sure of is that your police agencies are operating at the highest level of training and certifications. And we don't have that yet across the country. And that's why you find some communities that are backing off of this technology until more concrete foundings are done.
Yeah, thank you very much for that. And I just think about local elected officials. I have many constituents, though I'm in Wisconsin, that work in the Twin Cities in Minneapolis. I mean, we saw a real failure on the part of, in particular, the mayor of Minneapolis and the city council in addressing the riots that overwhelmed the city of Minneapolis last year. And a lot of it is because they didn't take control of their police department. There were a few bad cops in that police department, and they needed to take care of them. They did not do it. This is the same thing. They need to address the technology, and it isn't just the city of Minneapolis, it's cities across the country as well as states. They have the purview, they have the obligation to oversee their police departments, and they should do that, including in regards to using this type of technology. Final thing that I'd say before I'm going to yield to Mr. Biggs. This is the example of the limits of technology. I think about simple things like with children. They get better reading retention when they read off from paper versus off from an electronic format. And I think about police the same way here. You cannot replace boots on the ground and good investigative work with technology in all instances. I yield to Mr. Biggs.
That's correct.
I thank the gentleman for yielding. My question for you, Mr. Tolman, is this. U.S. Capitol Police has been given Army surveillance equipment to start monitoring Americans. And we have a report from a group called Surveillance Technology Oversight Project that says that they think that represents an expansion of police power and surveillance. And since I just have a few seconds, and then I'm going to ask the question to you, they point out the expansive nature of the surveillance state. How do you see this role of actually using military surveillance, giving equipment and technology to law enforcement? How does that expand surveillance state?
Well, in this particular instance, it's of grave concern because right now the Capitol Police are exempt from the Freedom of Information Act. So not only would it be difficult under rules of discovery for a defense counsel, you also would not be able to get transparency. So it creates a very powerful surveillance state in an agency that probably is unaccustomed and does not have the history of being surveillors of United States citizens. And so it's a recipe for disaster.
Thank you. My time's expired, Mr. Tiffany.
Yes, and I'll yield back with just one final thing. I think we should put into the mix here of our discussion what is happening with these text messages that they're talking about enlisting the phone companies, the wireless carriers to intercept people's SMS messages. I think that's a very chilling thing, and that should not be done by the Biden administration. And we should throw that into the mix in dealing with this issue as we go forward. Thank you very much, Madam Chairman.
Well, thank you very much. I know that these issues reach beyond administrations and deal with important questions that this committee is now bringing forward. Thank you so very much. It's now my pleasure to yield to the gentlelady from Pennsylvania, Ms. Dean, for 5 minutes.
Thank you, Madam Chair, and thank you for convening this hearing on innovative technology and its appropriate use and regulation under the law. I also thank all of our testifiers and advocates today for the enlightening things that you're able to share with us. Mr. Lee, I'd like to start with you. Companies like Clearview claim that through their database, it can instantaneously identify people with, quote, unprecedented accuracy. And yet Mr. Williams' story isn't unique. Such technology has resulted in, as we know, in at least 2 false arrests in Michigan and 1 in New Jersey. Organizations such as ACLU have expressed concern around the risk that Clearview's technology may have on undocumented immigrants, communities of color, survivors of domestic violence, and other vulnerable people and communities. Could you share with us some of the dangers of this face print and its misuse?
Absolutely, and thank you for the question, Congresswoman. The issues, there are a number of civil rights and civil liberties concerns with private access to law enforcement investigations and also with law enforcement's ability to purchase private data. There is little to no transparency, as we said before. I think a fundamental issue that we need to talk about with respect to this hearing is that these technologies are not accurate. And I think we are having a conversation as if they are. But there are significant error rates across the spectrum, particularly for marginalized and multi-marginalized communities. And so with little oversight, with little guidance, with no community input and no meaningful ways to engage in checks and balances, any conversation around the use of facial recognition technology within the criminal legal process is something that the Leadership Conference and many advocacy organizations push back against wholeheartedly. We should be thinking about a way in which to envision law enforcement and community engagement with law enforcement that does not require surveillance, near constant surveillance, nor near constant over-policing. And that is something that we need to push forward towards.
Thank you so much for that. So transparency, recognition that this is not a foolproof technology, and the error rate. There's an awful lot more we need to learn. Mr. Williams, of course, we are all moved by your story. Your young daughters watched as you were arrested for a crime you did not commit. How did your arrest and detainment affect your children, affect your family, affect your community?
Oh, thank you for the question. So it mainly affected my older daughter. My other daughter was only 2, so she didn't know what was going on, but she cried too. She just was crying because her sister was crying. But like I said earlier, I was trying to tell the story, but we got a short time. But we thought about taking her to see a psychiatrist because every time she see the story on TV, it makes her very emotional, and she starts crying, telling us to turn the TV off. And I'm like, I'm not going to jail every time you see it on TV, baby. It's just they're reporting a story again. And I had wrote something down. Somebody else had asked a question, but the police actually did investigate it, and with all those eyeballs on the pictures, nobody said these two guys don't look alike. Right? I don't know how the human part goes into it, but
Did you ever get any explanation for that?
no, nobody told me anything. And then we basically had to well, I can't say force them, but we asked them over and over and over again for a proper explanation or a way to say it with some type of what, I don't know what the word for it is, but they didn't seem like they were sorry. Like they didn't want to be apologetic about it. They were like, it happens. We made a mistake. And I'm like, that doesn't do anything for me, because all I did was come home from work and got arrested. And then, I mean, it's other stuff like I didn't get dinner that night. They had already served food at the prison. So I got off work. I got to go sit in a cell with no food and no drinking water, and just it was terrible for somebody that I wasn't ready for it.
I have to say, Mr. Williams, thank you for sharing that with us. I asked about your children, but we have to realize what impact it has had on you,
Right.
a long-term impact on you, to be picked up after work and arrested and detained so inhumanely and so incorrectly. So thank you, Madam Chair. I see my time has.
I didn't mean to cut you off. I don't know if y'all can hear I got a small speech impediment right at this moment, but last year I also suffered some strokes, and they're looking into that to see what actually caused the strokes. And I have no idea at this point. I had one doctor say it could have been attributed to stress or whatnot, and I don't know if he has a way to prove it. I don't know. But I did have strokes last year after.
God bless you. And please, I pray for your restored health. Thank you. I yield back.
Thank you. General Lane's time has expired. Mr. Williams' story should inspire all of us, among others, to find a bipartisan pathway forward. Let me now yield 5 minutes to Mr. Massey. You recognize Mr. Massey for 5 minutes.
Thank you, Madam Chairwoman, for holding this very important hearing on a very important topic. Before I jump into facial recognition, I want to talk about name recognition. Imagine a system, a computerized system, that instead of basing the adjudication of your civil rights on the distance between your eyes or the shape of your nose or where your ears are in relation to your cheekbones, it's based on the spelling of your first and last name and your birthday, and whether you might share a same name with somebody who's been convicted of a felony or may be in prison today. Well, such a system exists, and there is no judge or jury involved. It's called the NICS background check system. And the troubling thing about facial recognition as it exists today is there may be racial disparities in it, but we know that there are racial disparities in the NICS instant background check system. That's the system that you have to go through in order to purchase a firearm. And my friend John Lott, who worked at the DOJ recently, has found evidence that this system, by a factor of 3 to 1, produces false denials for Black males compared to white males, because they may share a similar name to somebody who is incarcerated within their ethnic group. And so, Ms. Goodwin, I appreciate the good work that the GAO does. You all do great work. I served on the oversight committee. We covered this topic before there, the facial recognition topic. The GAO released a report that said there were 112,000 denials based on the instant background check and only 12 federal prosecutions. Ostensibly 100,000 people committed a crime by trying to buy a firearm when they were ineligible. What we know from that is actually that they didn't commit a crime, but there were a lot of false positives. I got the commitment of FBI Director Wray in one of our recent hearings to look into this issue about whether there are racial disparities built into the instant background check system, because it's not very technologically advanced at all. And he said he would work on it. But I hope if this comes across your desk and that you have an opportunity that you might look into it. Is this something that your part of the GAO would examine?
Thank you, Congressman. And actually, that was my report. I worked on that report,
Excellent.
the prohibited purchases report. So we are happy to have a conversation with you about additional work we can do in that area.
Wonderful. Thank you so much. And thank you for that report. They do collect race information on the Form 4473. And so if we could, just take another level, it wouldn't have to be as deep and thorough as the report that you did already, but it would be very helpful, I think. I noticed that the beginning of this recent report on facial recognition started with, or your testimony, we surveyed 42 federal agencies with, law enforcement employees or internal law enforcement. And I thought, whoa, stop right there. That to me is troubling, that we have 42 federal agencies that have law enforcement. Maybe this is something that Democrats and Republicans could get together on. Maybe we have too many organizations. If the Department of Education has a police force, then maybe we have too many police forces at the federal level. But moving on, I wanted to ask one of our professors here, maybe Professor Lauren, about Brady material. Possible exculpatory evidence that's produced and that the prosecution may not want to share with the defense. And you mentioned that the way they get around some of the typical safeguards is they say, oh, we just used it to identify the suspect and we're not using it for the conviction. Can you talk about how that's problematic and whether defense attorneys can get Brady material from facial recognition companies?
Thank you for the question. In terms of I'll start with the last piece that you mentioned, which is getting Brady material from companies. In other words, there may be instances where, assuming a world that we don't quite live in yet, right, where facial recognition matches, say, are actually introduced in evidence in a criminal case. In those instances, the defense would certainly want to, and a competent defense would, sort of interrogate, right, what's inside the black box that generated this match, right? Well, one of the complicating features here is the proprietary nature of many of these technologies. And so we haven't seen this yet so much in the facial recognition context, but we have seen it actually in the context of DNA with certain more novel analyses of low copy DNA, et cetera, where the defense has been denied the ability to access the source codes, access what is claimed by companies to be proprietary information protected by trade secrets, and that intellectual property law has been invoked to quash defense subpoenas. So one of the many complicating features here, one of the many limits on the ability of the defense to vet this in a criminal context is this proprietary dynamic. Layered on top of that are a number of complications that derive from Brady doctrine and sort of disagreement over the scope of Brady and deciding when defendants are entitled to what we would call Brady material ex ante versus after the fact. I know you have limited time. I'm happy to pause there.
I see my time has expired, and I just want to say, I hope Congress will weigh in on this instead of like the Brady doctrine, allowing the courts to write this for us, because it does seem to be a problem, not just within facial recognition or yet, but across all the domains. And I yield back.
Thank you very much. I now recognize the gentleman who has dealt with some of these tech issues from a different perspective. Gentleman from Rhode Island, Mr. Cicilline. You're recognized for 5 minutes.
Thank you, Madam Chair, for calling this very important hearing, and thank you to the witnesses for your really compelling testimony. I want to begin with you, Mr. Williams. I'm just wondering whether, first of all, thank you for being here. Sometimes we talk about these issues in terms of public policy, and it's good to be reminded this actually impacts people's lives in a very profound way. And your story is one example of that. And my question to you is, did it seem like the police had even bothered to conduct an actual investigation, or did they appear to be relying solely on what the computer told them in connection with your arrest?
Okay, thank you for the question. So they did provide information. I didn't find out any of this until after, and then we went to court. But they had a lineup of I guess 6 guys, and we none of us looked alike. And I was like, who put this together? And I'm a guess because I wasn't there, but somebody picked me and said, "This is the guy right here. Do you see him in this lineup?" And I look nothing like the other guys. I was actually like 10 years older than all the other guys in the pictures, and they didn't use my current driver's license photo. They used one from 6 years ago. Well, at this point, it's 8 years ago. So.
Thank you. Ms. Director Goodwin, are there specific privacy concerns related to potential data breaches of facial recognition systems that are more concerning than breaches of other systems used by the federal government?
Yes, Congressman, thank you for that question. So yes, there are. So as I mentioned earlier, like your face is permanent, it's distinctive. If that information is breached, it's a lot more problematic and more concerning than if your password is breached, because you can change your password, but you can't change, for the most part, you can't change your face. And so there are major privacy concerns about what it looks like when the technology, when that information is breached.
Thank you. Mr. Lee, facial recognition systems have varying levels of accuracy, but we know they're especially ineffective at identifying people accurately from communities of color and women. And I'm just wondering, is there even any training that might help law enforcement to overcome these inaccuracies, or are they so embedded in the system that we should ban facial recognition outright?
Thank you for the question, Congressman. I think that we need to think about one context of policing that don't involve surveillance and don't involve overly surveilling marginalized communities and over policing them as well. And also, I would highlight that one of the things that we need to think about is that the technology doesn't, if the technology is not surveilling, or if the technology is not working to the same communities that it is trying to help, is this technology worth using in the first place? And so that's something that we need to think about, particularly within the context of civil rights concerns. Because again, Mr. Williams was wrongfully arrested, wrongfully detained for a crime that he did not commit based off of a lineup and setup and use of facial recognition technology that was not authorized by the local government, was not known by Mr. Williams himself, was not understood under any circumstances by the people using it, and had varying levels of accuracy across the board that were not given to Mr. Williams at the time or to the law enforcement or no.
I just interrupt you because I want to get to one more question. That, Professor Lauren, building on what Mr. Massey was asking about, what Mr. Lee just mentioned, we could simply require prosecutors to inform a defendant that facial recognition technology was used to identify them in any part of the process. That's one reform we could do. And in addition to that, we could require that the prosecutors disclose any other matches as sort of exculpatory statutorily, as Mr. Massey was saying with respect to Brady. I mean, there are things we could do to at least make the process more transparent and hopefully give defendants the opportunity to challenge this evidence.
I agree. There certainly are. There are other items that could be added to that. For example, to the extent the systems report out confidence levels, that is something that seems necessary to disclose. But I also think this issue of being able to get at that black box and actually know what's driving the result, which does then involve these questions around intellectual property, is really an important issue to get at.
And I just want to say, because the chair recognizes part of this is facilitated by the monopoly power of these large technology platforms, the fact that they're unregulated, the fact that they're collecting enormous amounts of surveillance. As Ms. Frederick said, the danger of integrating all of this presents real challenges. So I think it also requires us to regulate how private companies can provide this technology to law enforcement, and larger questions about how we have to rein in big tech. And I look forward to following up with Ms. Frederick in more detail on her very compelling testimony. I yield back, and thank you, Madam Chair, for the indulgence.
This time has expired. Thank you very much. We have other members who yet to ask their questions, so we will certainly move so that you can be included. It's now I'm recognizing Mr. Fitzgerald for 5 minutes. Mr. Fitzgerald.
Thank you, Madam Chair. Thank you very much. Fascinating stuff this morning. I just wanted to move maybe in a direction of a little bit away from the law enforcement aspect to just the private sector, which some of the members touched on this morning. As we see iPhones that use face recognition, anytime you're going through the airport now, you see the Clear system, which is allowing access for individuals to in airports on a regular basis. And then some employers now that we're reading are using this in relationship to their employees and kind of under the auspices of security. So there's a lot of different things happening in the private sector. The question I had for Ms. Frederick and Mr. Tolman, can you address some of the constitutional and privacy concerns of private sector use, particularly related to the difference between using facial recognition technology for verification purposes rather than just flat out identification?
I'll let Mr.
Ms.
Tolman.
Frederick? Yeah, Ms. Frederick.
Okay, so I'll start here. And I think generally from a wave top level, it's that outsourcing of surveillance that portends, I think, more potential concrete violations of the Fourth Amendment. I'm not a lawyer, I don't profess to be, but when I see the surveillance state basically outsourcing this job to private companies that don't fall under the remit of the United States Constitution, that's what starts to worry me as a citizen. Somebody who's been behind the powerful technologies that are employed at a commercial level, also by the surveillance state overseas. To me, I think it's that outsourcing to private companies that we need to think about when it comes to the Constitution, because some reports indicate that that is expressly made to skirt the constitutional protections. So I'll let Mr. Tolman give his broader expertise on this.
Yeah, I think that last point is where I wanted to go, which is oftentimes the use of third-party providers is an end run around, the protections. We've already seen that one court has indicated that the Baltimore Police Department violated the Fourth Amendment in its use of facial recognition technology. That would be one pressure point to push you towards utilization of a third-party provider. One in which you have somewhat lower standard when utilizing the evidence from them. And we don't know the nature of some of those partnerships. We don't know. That's the biggest problem right here, is the lack of transparency in the information, and we don't know what it is. Sometimes even the questions we need to ask in order to find out how pervasive that relationship is.
Yeah, thank you. Great answers. The other question that I would have for both of you would be, there's been some discussion about a full-out ban. And what we're seeing across the nation is some municipalities through ordinance have been, kind of progressively addressing this issue as it emerges, either as part of something that's under their control. Many times it is a municipal court system. And they're moving forward. City councils and even some county boards are moving forward, just full out bans. Is that practical at this point? And you can probably hear to my voice, it doesn't seem like it is to me at this point.
I would just quickly say that it is hard to imagine that this powerful tool is not to be utilized at all. I understand the calls for ban, but that's what makes this so difficult is there are circumstances in which this powerful technology may be the only thing that may save a victim or save a town from some horrific crime or from a terrorist attack, for example. And so getting this right in how we do authorize law enforcement to use it is right now the most important job I think this Congress has.
I prefer to
Ms.
think of
Frederick,
it
you have a
more as
comment on
a,
that?
yes, sir. I prefer to think of it more as a tactical pause. Take the time to get it right. So I think there are measures with which we could do so. Lawsuits. It's being fought in the courts as well. ACLU is suing Clearview AI. It's Illinois' arm filed a 2018 lawsuit against Chicago police. So there's other mechanisms as well as municipalities to take that tactical pause, take the time to get it right.
Thank you. Thank you, Madam Chair. I yield back. Thank you.
I thank the gentleman, and I'm now pleased to recognize the gentleman from California, a former AUSA, Mr. Liu. You're recognized for 5 minutes.
Thank you, Chairwoman Sheila Jackson Lee. I'm super excited that you called this hearing. My office and I have been working on facial recognition for over 2 years. The reason it's taken so long is, as the chairwoman has aptly stated, it is a can of worms. When you look at this issue, it can get very complicated. We have worked on legislation that is essentially complete now. It basically requires a warrant for most cases of the use of facial recognition technology. It sets auditing and bias testing standards. It requires reporting. It prohibits facial recognition technology for most First Amendment protected activity, and a number of other provisions. We're going to circulate that legislation to the members of this committee, both Democrats and Republicans, for your review and comment and co-authorship. So thank you, Chairwoman Lee, for this hearing. My first question goes to Professor Lauren. As we already know from this hearing, facial recognition technology implicates the First, Fourth, and Fifth Amendments. I want to talk about the Equal Protection Clause because there is this disparity in accuracy in terms of the color of your skin. Would it also be an equal protection violation if we had government agencies deploy this knowing that similarly situated people are being treated differently in terms of surveillance?
So thank you very much for the question. I think that in answering the question, I want to sort of distinguish between constitutional doctrine as it stands and maybe a more intuitive sense of what is rightfully understood to be constitutionally problematic. So I think the challenge with using the Equal Protection Clause and the doctrine around it to get at these issues of bias in facial recognition is that existing Supreme Court doctrine requires that essentially discriminatory intent be proved in order for state action to be deemed to be a violation of the Equal Protection Clause. And that presents a hurdle when one is working with evidence of disparate impact, right? There's an evidentiary gap often in getting from the state realizes there's this disparity to the state wants to discriminate on the basis of race or on the basis of sex. And that has been a real difficulty in using the courts to get at these problems of disparity. Now, that doesn't mean that it wouldn't be understandable, appropriate for Congress to say, we see a problem in these disparities and want to legislate to require that that disparities themselves be sufficient basis for limiting the use of technology, et cetera. Of course, one needs to think about what the hook would be for that in terms of Section 5 or the Commerce Clause or something along those lines. But I think that existing doctrine presents a challenge because of this requirement of discriminatory intent.
Thank you. I appreciate that. My next question goes to Professor Friedman. First of all, let me take a step back and say I do agree with Dr. Alexander and Mr. Tolman that we can't just ban this technology. If you look at the course of human history, nearly impossible to ban technology, but we can regulate it. And Professor Friedman, because there's so many different iterations and possible uses and situations for facial recognition technology. What do you think about imposing a warrant requirement that can actually take into account all the different particularized factors before deciding whether any specific case we would use facial recognition technology?
Thank you for the question. I just want to make a comment about the ban versus moratorium or strategic pause point, which is just, I think everybody's recognizing we got the cart out ahead of the horse here, and that's the problem. And so regulation is the only shot we have of getting the horse back out in front. Warrant requirements are useful in some circumstances and not others, and it depends on the use case for the technology. So for example, if the use case is identification, which is what most agencies are doing right now, they take a probe photo and they compare it to a database. A warrant requirement makes sense, but only to get permission to use the technology because there is a reasonable belief that the photo that you've got is somebody that is suspected of a crime that is permitted under the statute. And I, for one, would only allow the use of facial recognition for very serious crimes. So that is a use of the warrant that makes sense. But the warrant can't tell you, for example, that a particular individual committed the crime. It's just to use the technology.
Great, thank you. I see my time is up and I yield back.
This time has expired. I think we have present with us a distinguished gentleman from Utah, Mr. Burgess. Owens is recognized for 5 minutes.
Thank you, Chairwoman Jackson Lee and Ranking Member Biggs. And thank you for holding this very important hearing today. The concerns surrounding facial recognition technology demands a bipartisan solution, and I look forward to working with my colleagues to address these concerns. I'd like to thank the witnesses today and Mr. Williams. We all agree on the unfairness of what you and your family have had to endure. Thank you so much for your decision to stay in the fight, to share your experiences, and do your best to make sure no other Americans have to experience what you and your family have gone through. I'd also like to give a special welcome to my friend and fellow Utahn, Mr. Brett Tolman. Along with other accomplishments mentioned previously, Brett has also been a very strong advocate of criminal justice reform. I'm finding the upside of being toward the end of the questioning is that the remarkable education I've personally received over the last couple hours. The downside is the questions I had coming into the session have been answered. So I'm going to yield the remainder of my time back to Ranking Member Biggs. But before I do, I'd like to highlight something that was mentioned previously, and that is the heartwarming bipartisan concern that I'm feeling and seeing as we go through this topic. I'd also like to point out that as we do come to our solutions of solving the increase of crime that we're seeing everywhere, that we cannot rely on technology. Technology is our tool to help support human relationships, and all human relationships are based on respect. We cannot continue to demand, we cannot continue to demean and disrespect the good servants, the 90% of good men and women policing our communities, and expect technology to make up for it. I'm convinced that this committee will find the solutions and address the concerns of facial recognition technology. Let's take the same passion to bring back the respect for our law enforcement officers, men and women, the same respect that I had when I experienced as a child. Our communities will have the benefit of more confidence in our future innovations once we have that accomplished. And with that, I'd like to yield back my remaining time to Mr. Biggs.
I thank the gentleman for yielding, and Madam Chair. And just a couple quick points. We've had this has been a very enlightening hearing. We've not really addressed, in my opinion, enough the question on reasonable expectation of privacy that's been shattered by the data scraping that goes on by private concerns to develop these databases, which are being referred to. I hope that we can expand our investigation into that, because I don't think the question has been settled through the courts yet either. And if it has, I haven't seen it, but we certainly need to get to that. I also want to comment on Mr. Liu's legislation. I look forward to reading it, Mr. Liu, and I appreciate your efforts on it. And I hope that we can also integrate some of the work that was done in the previous iteration of the OGR committee with Chairman Cummings and working on that as well. So I look forward to seeing Mr. Liu and hope that you can get that to us soon. Appreciate it. And then I want to ask Mr. Tolman this question, because it really gets to the heart of some of what we're talking about. Not, I mean, this is just, as Mr. Liu said, this is a can of worms when you open this thing up. But when we start bringing together other technologies, we've discussed this SMS and email, and we've moved from just using this in mere identification, which is in and of itself a problem, to the potential to track movement. This notion of science fiction type pre-crime, stopping pre-crime. In just a very brief, what's your take on that in a very, very brief way, that we're on a spectrum that's going to keep moving to trying to stop people from committing crimes before a crime is ever committed using this kind of technology and others combined?
Yeah, I share the concern, and we have seen that when law enforcement is given additional technology, their first instinct is to utilize it because they have a sincere and genuine desire to work on behalf of our communities and the victims of crime. However, they're often the last one to actually ask the questions, should we utilize this technology? And that has to be the reasoned discussion of members of the legislature that identifies this. We are already seeing that speech and social distancing under COVID and areas where we have not ever been are now areas where we are focusing law enforcement technology and action. And because of that, we're on a slippery slope, and I would share your concern.
Thanks, Mr. Tolman. I hate to cut you off, but I want to finish from our side where we started with the chair, and that's the testimony of Mr. Williams. So I'm looking here to find it. So yeah, Mr. Williams, in your testimony, your written testimony, you said, quote, "I don't want anyone to walk away thinking that if only the technology was made more accurate, its problems would be solved," close quote. Well, I think the issues we've discussed today are not just issues with accuracy of the technology. I think we're talking about a total invasion of privacy, which is absolutely unacceptable, which at some point is going to give too much power to the state. And we've actually seen it already in your case, Mr. Williams, and others that we've discussed today. So I'm looking forward to working with the chair and also Mr. Liu and others on this committee who have a sincere interest in resolving this issue. Thank you, and I yield back.
Thank you, Mr. Biggs. You're absolutely right. We have a sincere interest in resolving this issue, and there are layers of issues that I think that we can respond to as a committee in a bipartisan manner. Speaking of bipartisanship, I'm delighted to yield to the gentleman from California, former sheriff, Mr. Correa, for 5 minutes.
Thank you, Madam Chair, for holding this most important hearing. And I want to thank all our witnesses today for some very good testimony. And Mr. Williams, also say, hearing your story, being in a cell for 30 hours, not knowing why or what you were accused of is alarming, tragic at many levels. You know, as we think about society today, when you give your fingerprints, you give permission to have your fingerprints taken. When you go in for a live scan, you say, here are my prints, take the scan. When you give your DNA, you give it with permission, knowing that somebody is going to do a DNA scan on you. But when it comes to facial recognition, no consent is necessary. In fact, most people don't even know that their information, their facial information, is being collected by somebody, a private entity out there. Mr. Bertram Lee mentioned that 133 million Americans, let me repeat that, 133 million Americans have their facial recognition data in a database some way or another in this country. And I presume that most, if not all, gave that information or gave their facial information without any consent or even them knowing that that data was taken from them. So Professor Lauren and Professor Friedman, today I have a question for you. We discussed the Constitution, our rights, but in effect, are there any regulations, laws that govern to limit in any way possible a private entity's ability to collect facial recognition data? As a taxpayer, as a citizen, am I going to have to accept the fact that a private firm has my facial recognition data to sell or use as they wish? Question.
Professor Lauren, if I may.
Please go ahead.
I just want to appreciate the question at a couple of levels because I think it's so critically important. It's very easy to fall into the language of constitutional rights here, and the constitutional rights are obviously critically important. But the interpretation of the Constitution by the courts often doesn't touch the kinds of things that we're talking about, in part because the technology is rushing ahead of the courts. And so you could not be more correct that there's an urgent need for regulation, for legislation, both as to private companies and as to law enforcement agencies. And then as to the private companies, I don't know of any congressional law that deals with this. Some states have stepped in, like Illinois, in this space, but for the most part, there's a void. And I think the need for legislation is essential.
Ms. Lauren?
I can really only essentially echo what Professor Friedman said. He speaks my mind. I think that there is a tendency actually to sort of overly prioritize the constitutional stuff and to miss the fact that actually the Constitution is a floor, not a ceiling in terms of protections, right? And in fact, often the constitutional protection is lower by design because the courts say, really, there are details for Congress to figure out. It's really not our institutional place. And so
if I ask you again, let me repeat my question. As a taxpayer, as a citizen, am I going to have to accept the fact that right now a private third party has my facial recognition information and they can do whatever they want to do, sell that information to whoever they want to sell it without any repercussions, without any regulation, without violating any kind of a law? Is that the case? Is that the state of the laws in this country today?
the best answer I can give you without presenting myself as an expert in every statutory scheme governing, for example, electronic communications, et cetera, is that I do think that there are at least some data privacy regimes, statutory data privacy regimes that would limit some activities. But in the main, there is very little regulation currently. And certainly the Constitution has virtually nothing to say about private non-state action. And that is why congressional action is so important.
So I'm left here with a very unsettling feeling that I essentially have no remedy for somebody using my facial data recognition information for whatever they want to do with it.
Well, you can create one. You have Congress has the power to regulate products and moving in interstate commerce. You could change that state of affairs if you chose to.
Thank you, Madam Chair. Ran out of time, I yield.
The individual ran out of time. Mr. Correa, we are all running out of time. This is such an important issue, and I'm very grateful for all of my members. And I listened to, as I yield just for a moment, I listened to Professor Friedman over and over again about regulation, and that's what we are having this hearing for, because we're working on legislation, and I look forward to working with Mr. Biggs, but also with our colleagues who are likewise working on legislation to be able to address the question of a regulation or a construct that needs to address this question. So thank you all very much. It's my pleasure to yield to the vice chair of this subcommittee from Missouri, the gentlelady, Congresswoman Bush, for 5 minutes.
But thank you, Chairwoman, for convening this hearing. We as a committee have spent significant time addressing the brazen and broad scope of power held by law enforcement agencies, from the FBI to various prosecutorial entities under the Department of Justice. And time again, we are met with concrete examples of unfettered law enforcement practices that not only undermine our fundamental civil liberties, but our basic principles of human dignity and security. When the ACLU conducted a study with members of Congress and a mugshot database, 28 members of Congress were falsely matched, including the late Congressman John Lewis. And this was members of Congress, public officials. Imagine what it's like for everyday people across this country. And what we do know of this technology is that the darker your skin tone, like mine, the more likely you will be falsely identified. During the Ferguson uprising, following the murder of Michael Brown Jr., I recall wearing bandanas as a response to the tear gas. It was during that time, though, that we realized that we needed to wear bandanas because of the likelihood of facial recognition technology being used against protest movements and surveilling each and every one of us involved in the Ferguson uprising. Director Goodwin, the GAO found that 14 agencies reportedly use facial recognition technology to support criminal investigations. Yes or no, was FRT used by the federal law enforcement agencies during the protests following the torture and murder of George Floyd? It's just a yes or no.
Yes.
And what are the collateral consequences of protesters being identified by these technologies?
So, Congresswoman, we didn't go into that issue. We raised the concerns about privacy and accuracy. So, of course, with accuracy, the concern is that people would be misidentified by the technology, and that could have adverse consequences. The privacy issue is that their faces, a person's face could be out there and could be used, in a number of ways. So our focus was to look at the lay of the land for how law enforcement were using the technology.
Thank you. In 2016, it was reported that police used facial recognition to surveil crowds during the Freddie Gray protests to find people with outstanding warrants. Mr. Lee, are there any protections for protesters' identities when they are in public spaces but engaging in First Amendment protected activity?
Thank you for the question, Congresswoman. And this would be, in our mind, a clear violation of the First Amendment, but also there are serious privacy and civil liberties concerns with the kind of use of facial recognition technology that we saw not only with the George Floyd protests, but also that we saw with LAPD using ring cameras to surveil Black Lives Matter protesters. We have serious concerns in this, and there are serious civil rights and civil liberties concerns about the tracking of protesters, especially in these circumstances, and especially when the technology is not well used or very accurate.
So, Mr. Lee, how does the use of the facial recognition technology used to identify protesters, how does that influence the public perception or opinion of law enforcement or even the high-tech policing?
There is already a tenuous relationship between communities that are over surveilled and over policed and law enforcement. We've seen this time and time again over the past year. And that's something that I think Congress needs to keep in mind when looking about regulating facial recognition technology. And these are tools used by law enforcement to disproportionately target Black and brown people across the nation. And we need to keep that in mind, and the civil rights of and the civil liberties of those people in mind as we think about what the next steps are. That's why we, as a civil rights community, have asked for a ban or a moratorium and a tactical pause, to use the language of Ms. Frederick. We think that it chills protest, it chills speech, it misidentifies, and it does not work.
Thank you so much, Mr. Lee. There are local solutions that are being
Ms. Bush? Are we able to get Ms. Bush connected? Let me, I think we may have lost Congresswoman Bush. Thank you very much, Congresswoman, for those very insightful points that you've raised. I have been impressed by the direction of our questions, the depth of our questions, and certainly the importance of our witnesses. Mr. Biggs, I have questions that I'm going to utilize at this time, but I'm happy to yield to you. You have been certainly rewarded with time, but I'm happy to yield with you before I make my final inquiries that I hope will be important to the record of this hearing and proceedings. Mr. Biggs?
Thank you, Madam Chair. And I know you'll be surprised to hear this, but even though I have many more questions and comments about this, I appreciate those that have participated. But I'm going to limit my comments right there. And again, thank the members, the witnesses, and yourself. Thank you, Madam Chair. I yield back.
Thank you so very much. And thank you to the witnesses. I'm going to proceed with some questions that I think are that I did not proceed with. As I do so, I want to make sure that I thank all of the witnesses. Again, you'll probably hear me thank the witnesses more than once. I'd like to submit into the record, and then I will begin just some questions that I think are very important. I want to submit into the record the GAO report that I believe was entitled Facial Recognition Technology, Federal Law Enforcement Agencies Should Have Better Awareness of Systems Used by Employees. I think that is shocking, and I think that is also indicative of what I think Dr. Alexander made mention of in terms of the numbers of law enforcement and the utilization of this tool without training. I will, Mr. Lee, come to you for a broad question on civil rights, but let me ask Dr. Alexander, 18,000 police departments. One of the reasons why Noble has been so instrumental in helping us push for the George Floyd Justice and Policing Act to find a regular order that will help police, not diminish police. But how do you respond to the idea? And I also, to my members, believe that we should have a follow-up hearing with some of our federal law enforcement representatives that were cited by this excellent report that Dr. Goodwin has put forward through the GAO. And that may be in a classified manner, but we will be presenting that in the future. But Dr. Alexander, to note that it was determined through the federal system that employees were using this system without their hierarchy knowing, what do you think that means for the 18,000 police departments, or this kind of technology comes into their possession, and how that relates to your point about police community relationships, but also victims, and I'm going to call him a victim, and I hope that he can be made whole, and that is Mr. Williams and his family. Dr. Alexander.
Thank you, Madam Chair. Yeah, there's over 18,000 police departments in this country, and oftentimes we're finding more and more we got 18,000 different ways things are being done, and how they're being responded to, how they're being disciplined, how they're being managed, how they're being trained, etc. And when you have one organization, and all it takes is just one, quite frankly, in the eyes of the American public, they also all see policing as the same. Doesn't make it right, but that's the reality of it. And if I do something well as a police officer, we all jump up and down and say, hey, but if I do something horrible, we all have to take that hit too. But to your question, I think it becomes important to recognize that appropriate training is going to have to be regulated at a federal level. And there's going to have to be some federal standard, I truly believe. The same way we do with fingerprint and with DNA and with other forensic methods that have proven to be of value in the law enforcement and public safety community. because the whole idea about this particular piece of technology is that it's very convoluted and it's very complicated. And there are going to be cases that are going to go before the courts that we haven't even thought about yet as it relates to this technology, still yet to be examined. So I just think, Congresswoman, that due diligence will be given to these local agencies across this country if they have an opportunity to be well trained, if there be a standardization to the utilization of this technology, there be ongoing certification, there be practices that are held to the highest standards of science. And in addition to that, I think it becomes important as well too that the public understands what facial recognition technology is, because we've talked about it a lot within the context of policing and within Congress, but a lot of people in our communities across this country don't understand exactly what it means. And when they do hear about the cases, they hear about the cases that are often associated with that of Mr. Williams.
I would think minimally that, and you don't have to answer, I'm just going to make this as based upon your response, minimally that police departments need to be aware of when the technology is in their possession and whether or not it's a detective with sloppy work, that is being used, and the individuals given the authority to use it are well trained and, as you've indicated, certified. I'd like to just place that on the record because the title of the GAO report said that our federal agencies should have a better awareness of these systems being used by employees. That's actually shocking and amazing to me. And I think that can be parlayed out into the field with the other 18,000 police departments. But thank you for your answer. I indicated that my concern has been the unreasonable search and seizure. I'd like both Professor Lauren and as well, and I think this was raised by one of our members, but I'd like maybe a succinct answer from both of you. Professor Lauren, with your academic background, you focused on criminal procedure. I don't think that we're without tools. We have the ability in Judiciary Committee to look at the federal criminal procedure as we do civil procedure. But in any event, Mr. Tolman, as a former U.S. attorney, in cases where an investigation results in prosecution, should prosecutors be required to inform the defendant that facial recognition technology was used to identify them in any part of the process? Obviously, it is investigative, and should alternate positive matches be required to be produced as that investigation goes forward, and if it ultimately comes into court? And I know that one of our members mentioned the Brady defense, but how should we respond to that? Professor Lauren first, and then Mr. Tolman.
Thank you, Chairwoman. My bottom line view is it's absolutely right, the observation that with respect to federal criminal procedure, there are some very direct interventions that that Congress can make. And while I think the scope of Rule 16, frankly, is always sort of a fraught discussion, I think there are important limited interventions that can be made in terms of requiring access to facial recognition, to the fact of the search, to alternative matches, to information on confidence levels. And again, as I said, I think to the extent possible, it's really essential that defense have access to the algorithms, to what's inside the black box, to be able to evaluate the reliability of the technology. And that could all be a matter of sort of statutory change without having to worry about the court sorting through the morass of whether Brady doctrine encompasses that.
And I would simply add
Mr. Tolman, thank you. Yes, Mr. Tolman.
The professor is absolutely correct. I agree with everything she just articulated. I would add that unlike a lineup where a prosecutor is required to hand over alternative individuals that might have been placed in the lineup and the rationale for the lineup that was utilized, facial recognition technology requires the prosecutor and should require the prosecutor to turn over more if the intention is to give the defense counsel all that it needs to assess the reliability and the admissibility of such evidence. So we're in a new ball game with this technology, and it will require more to be given from a prosecutor to a defense attorney under the strictures of our constitutional protections.
I would just add one additional note, which is that it's essential that timing be addressed, because if defense counsel is only able to access this on the eve of trial, it does no good in terms of evaluating whether a guilty plea is an appropriate resolution, does no good in terms of preparing to challenge the admissibility of evidence. And so early discovery is important as well.
Early discovery and early knowledge, is that my understanding? Thank you so very much. Let me quickly, Professor Friedman, I just want to just clarify, when you said regulation, in what framework are you speaking?
So, I think what's important here is comprehensive regulation that does two general things. One is regulates the technology as best as we understand it right now. So we know that there are very serious problems with the technology and they need to be addressed. And then the other is there's a lot we need to learn. And so one of the things that Congress could do immediately is instruct some entity like NIST or NIST to actually test the technology under operational conditions, how law enforcement is using it, because there are very, very serious concerns about accuracy and bias, particularly racial bias. And we get numbers reported, but those numbers bear no reflection to how law enforcement's actually using the technology. And what little we know from NIST suggests that those error rates may be quite high, as others have indicated. So there's a list of things that I think we should, that Congress should have NIST study. And then I think there are a list of immediate safeguards we could put in place. For example, best practice protocols about what it means to have a human in the loop that verifies what the algorithm does.
Thank you very much, Ms. Frederick. And I'm going to finish with Mr. Lee. Ms. Frederick, you have been keen on the providers or the tech entities that control this technology. From your perspective, what would be a regulation in that entity, in that arena?
Well, ma'am, as you know, I work for the Heritage Foundation, and we are about limited government, and we do not really support regulation when it comes to, robust regulation when it comes to private entities. So my solution would be, we have to encourage the programmers within these companies, the leaders in this company, to institute those privacy by design mechanisms. So make sure in the design phase of creating an algorithm, you are imbuing it with privacy protections. And that's why I sort of hearken to the differential privacy. We have methods of encryption that are getting more and more powerful and much better, decentralized models of data storage, federated models of machine learning. So if we if you as Congress can sort of impress upon these companies that they need to build in these data privacy protections, I think that's a good start point, short of actual regulation on private companies.
Well, in the spirit of my ranking member, this is a bipartisan hearing, and so we wanted to make sure we welcomed your thoughts as well, which will be very helpful to us. Let me have Mr. Williams, and then Mr. Lee, you have the last word. Mr. Williams, I think you have heard from all of us. We are appalled at what happened to you. We are stunned, but we know that there are good intentions. I will be introducing some articles that where this technology was used. We also heard from Dr. Alexander that there are good policing out there working to do positive things, but in your instance, you fell into a very bad trap. What do you want to leave us with as a victim, not a victim in your own self, but a victim of this technology that should not have happened? And again, I started out by apologizing to you and your family, and we'll be eagerly watching your lawsuit, I think possibly pursued by the ACLU, if I'm correct. But what do you want us to know as you end your testimony here? You're unmute.
Yeah, I'm unmuted. Thank you. I first want to say thank you for inviting me to come tell my story, and I hope that going forward we can figure out a way to I guess, like they said, to regulate because it's already being used. So we need to get it fixed so that it works more in a way that it works properly, I should say. Because in the current state, it's wrong. Is they get it wrong even when they get it right. And I don't know if that makes sense. Like you don't really have a say so, and it's been said throughout the time that nobody's ever signed up to say, hey, use my picture from my ID in your mug book. Like I said a little earlier, they didn't even use my current driver's license. They used one previous from when I guess I might have looked younger at that point. I don't know. But I guess all your information is in the system, so it's available to be used. And I was asked a few times about how my daughter took it, and I don't know what the lasting effect is on them. All I know is at this point, she's upset every time we look at it or see it. So, I mean, I don't know. I hate to say I'm thankful that it was a felony larceny, but what if the crime was capital murder or something like that, and then they just came to my house and arrested me. I don't know if I would have got a bond to get out and be free to even talk to you at this point out, because the courts system is so, it's so backed up that they probably wouldn't even have got to me yet, and I'd still be locked up for something I didn't do. Right? Like I kind of cringe to think about it like that, because I did not get to say anything. I didn't have any rights read to me or anything. They showed up, asked me my name, and I asked for a warrant. They didn't just bring one. I kind of resisted arrest, but I was in my driveway and I'm like, what are y'all? I was like, what are y'all doing? And he was like, are you Robert Williams? He was like, all right, then come on, you under arrest. And I'm like, for what? And he like, I can't tell you. And I'm like, you can't even tell me what I'm under arrest for, but I'm under arrest. And they took me immediately down to the detention center, and I got fingerprinted and mugshotted right then and there. And I assumed that my fingerprints were clear and I'd be out. And that didn't mean anything. It didn't mean if my fingerprints went in, so what? Right? And now they have a mugshot to add to it. It was so backwards, if that makes sense, right? And I just feel like I'm just a regular, and I thought I knew the law, and I was wrong. So hopefully we get some change.
Powerful, Mr. Williams. You're seeking, I would just simply say you're seeking justice, and you deserve
Yes,
it. You really do. Mr. Lee, you obviously represent a sort of a family of those who've been fighting these issues dealing with justice in the criminal justice system. And so having listened to Mr. Williams, and I know the position of a ban and or moratorium, but just if you would end us on the enormity of the problem if we were to have facial recognition used randomly in this massive hierarchy of 18,000 police departments without some intervention. It may be your form, it may not be, but what can happen to persons who wind up like Mr. Williams? I'm shocked that you can't get a reason why you're being arrested. I thought you were entitled to that, but they use facial recognition. The people that he was in the lineup with didn't look like him. It didn't look like him when they put the picture up to him. So what how is that just a undermining of civil rights and civil liberties in this country, if used as it seemed to have been used with Mr. Williams?
Madam Chair,
Mr.
I
Lee?
think there are, yes, Madam Chair, I think there are there's a broader context of policing that we must keep in mind that is especially instructive when talking about the case of Mr. Williams, but also why so many, the Leadership Conference and its coalition organizations support a ban, moratorium, and Ms. Frederick, I'm going to steal tactical pause from you here on out in my policy conversations. It's because we can't separate the tools from the context of the American policing system. We have evidence of that system over decades, centuries, of how Black bodies and disproportionately Black people are treated within the criminal legal justice system. We can't separate those tools. And then if you add the whole history of that criminal legal system to a tool that is known in the best of conditions to be biased against Black people and against women, and misclassifies or misidentifies members of the LGBTQ plus community, people with disabilities, right? So many members of the community that we need to protect because of their protected status and the history of harms that have been done onto their bodies throughout centuries. Then we need to have a really real conversation about whether this technology actually works the way that we think it does. And it doesn't. And that's been proven time and time again, whether the National Institute of Standards and Technology, whether the research by Joy Buolamwini and Timnit Gebru, right? Whether we're talking about the ACLU's use of the Amazon facial recognition technology to identify even members of Congress who are public figures. It's being used in communities that are already over-policed and over-surveilled. And it is the least likely to work for those exact same communities, and the community is not involved in the process. There is no public airing of widespread use. Congress has not been asked, or Congress has not legislated on these topics. And then there's even an opacity with which the tech is used that is compounded by the opacity of policing practices in general and law enforcement agencies. We don't know still, even with the GAO report, how deep law enforcement is using facial recognition technology, nor the full extent of those technologies writ large. And community engagement is not a checkbox, it's a continuous conversation, and no one knows. There are secret hearings, there are classified briefings, but the public does not know the full extent of facial recognition technology and really broadly digital evidence capacity of law enforcement writ large. We will continue to consistently call for a moratorium or ban on these technologies, and we would be more than happy to work with this committee in Congress to imagine a solution and imagine a world of policing that puts the civil rights and civil liberties of marginalized communities first, not last, and not using these same communities as basically test cases when these technologies do not work.
Thank you so very much. Thank you so very much. Thank you to each of the witnesses for their profound testimony. And thank you to my members or the members of this committee. And Mr. Biggs, as ranking member, thank you for joining me on, I believe, a hearing that will be very constructive going forward, as evidenced by the questions and the responses, and of course, the expert witnesses that we had today. So this concludes today's hearing. Before I conclude, I'd like to submit into the record Center for Strategic and International Studies, The Problem of Bias and Facial Recognition, May 1, 2020, Washington Post article, How America's Surveillance Networks Help the FBI Catch the Capitol Mob, and that is dated April 2nd, 2021. And then the Washington Post responding to the federal study confirms racial bias of many facial recognition systems, cast doubt on their expanded use, December 19, 2021. I want those articles submitted into the record. I thank again our distinguished witnesses for their attendance and